Any mentioning in
may I-
commercial bench matter?
may I no,
Commercial bench matter mentioning? Regular bench matter mentioning?
may I permit to mention one matter, my lord?
Because I filed one application in non-petitioner administration suit, non-commercial. Filed on one application with notice of motion, but unfortunately, one inadvertent mistake was cropped up. Though there is a date here, when the matter will be moved before your lordship is not mentioned. So I beg leave to serve again and to file it, kindly direct it to appear in the list of. তাহলে কি আমি আসবো পরে?
May I permit
Aji
to mention
suggest
one
koro.
matter, my lord? One consent
That's a great.
affidavit sent by the one of the legal year. It is from USA, my lord. It is notarized, my lord. Leave may be granted to file it, my lord, without
What is
apostille, my
this?
lord. Kindly,
Consent to?
yes. একটু দেখেন।
May I have lordship?
Wait. Consent? Is a consent right? Notary's consent क्या acceptable है? আবার ও বলবে যে আমি করিনি এ করবে। Where is this person?
In USA, my lord. Also, Vokalatnama also sent, my lord. This is the Vokalatnama also, my lord. This is the Vokal. Executrix is the sister, my lord. He is the brother, my lord. And another brother also, my lord, give consent. Two son and one daughter, my lord, of the testatrix, my lord. My lord, another brother also give the consent. He executrix is the, my lord, the daughter, my lord, sister of the this person, my lord.
Okay.
They have no objection.
Lord, may I mention one correction?
May I have lordship kind leave to mention one new chamber application which may come up in the list as a new chamber application. This is a new chamber application. It's based on a one substitution application in connection with a partition suit.
Yeah.
Grateful.
Already in my case, there is a minor correction in PLA matter. Dictated order, this typed copy of order does not correspond to that. So there is instead of prayer B, prayer A has been allowed. It should have been in fact, in open court, it was pronounced that the order is for citation, but it has been finally disposed of by grant of probate. So
Which
that
court?
correction is to be required.
On court.
Date is 17th May 2020. On benches.
May I be permitted to mention, my lord, a PLA matter for final order. In this matter, my lord, two of the attesting witnesses, they were both are right, my lord. There was a attending witness was into a box and it was also examined. That was over, my lord. It is appeared pending for final adjudication by your lordship. Since 2017, my lord. Final order. One quantity is cost, my lord.
ঠিক আছে।
Since, my lord, there is a attesting witness, my lord, attending witness was examined, my lord. It is, my lord, pending for final adjudication. May I place the last order, my lord? No, after my lord's order, they will place before the Testamentary department for scrutiny, and thereafter they will again send it for final adjudication. Before that, my lord, judicial order is required. The other
Give the
formalities have been complied with. These are the series of order, my lord. There was a change in the brief, my lord. The learned counsel who appeared on the last occasion, he took time for preparing list of dates, placing the list of the order and the events. But thereafter, my lord, it has not appeared much.
List, huh? List proof.
Lordship, may I be Lordship, may I be permitted to mention a non-contentious PLA matter? Lordship, I had mentioned it last week. There is an issue pertaining to the jurisdiction of Lordship with the district courts, Lordship. Lordship had directed me to mention it next week again.
What is the difficulty?
Lordship has concurrent jurisdiction with the district court. So the matter is not being listed because the deceased and the assets of the deceased are within the jurisdiction of the district court. So
It is judgment pending, actually. It is judgment. No. তোমাকে বলে দিন তাহলে জাজমেন্ট এগুলো তারপরে হবে।
Another matter, Mala, may I mention, Mala, of the correction of an order of Justice Arindam Mukherjee one.
Correction cannot be made. You have to mention, huh? List.
May I be permitted to mention, my lord? My lord, this is a non-contentious PLA application. The application was filed with the certified copy of the will as the will was lost. And my lord, on the last occasion, we have undertaken to produce a witness to prove the certified copy in solemn form. And the matter was out of list to liberty to mention, my lord. I'm praying for inclusion.
Okay.
Order so much.
May I be permitted to mention, your lordship, item number 60 of today's list, your lordship. 63. The matter is under the heading framing of issue, your lordship. The matter was supposed to be under extension because an order was passed by this honorable court dated 15th of May for amendment of length. The time was expired because of the vacation. I had mentioned earlier for extension of time. So let it be just one line of order needs to be passed for extension of time for amendment. No, কোনো application.
Record is application file for extension. When did the time expire?
It was on 15th of May. Order was 15th of May. Order before vacation. The order was expired just one day before vacation. Because of the vacation, the same was.
File an application for extension of the time period, modify the order, and then send it.
May I have your lordship leave to mention the matter?
Application.
The suit of 1999, my lord, it was heard by other bench, my lord, about 38 days. My lord, I mentioned the matter, my lord. Witness has been completed. Witness action was completed. Only last defendant, last witness is in the box. My lord, I mentioned the matter earlier. My lord, your lordship's direction was to appear in the.
Lord, may I have your leave? Lord, may I have your leave to mention this matter? My lord, this is a 1999 matter. My lord, the erstwhile advocate for the petitioner is not traceable, my lord. I'm praying for leave to file my wakalat number without taking change, my lord.
Without taking?
The NOC, my lord.
Where is the
erstwhile advocate for the petitioner is not traceable, my lord. Even he has left practice or he's not, he's dead or alive, we don't know.
You find out and get a no objection from the erstwhile advocate. Not like this, I cannot give leave like this. So, next.
I pray for my lord's kind leave to mention a non-contentious probate application. My lord was pleased to fix the matter, my lord, on 24th of July at 12:30 p.m., my lord, for examination of the witness, my lord. When it was communicated to the witness, my lord, only on that day he is not in Calcutta, my lord. May it be fixed on any other day?
Non-contentious.
Non-contentious, my lord. Since it was filed with the copy of the will, my lord, it was to be proved in solemn form, my lord. The will has to be proved in solemn form. For that purpose, my lord, the witness has to be examined. The attesting witness, my lord.
24th July is the date.
Yes, my lord. My lord, may I produce my lord's last order? My lord had fixed it at 12:30 p.m., my lord. It was communicated to the witness, my lord, on that particular day he is not available. 25th to 8th August he is available. After that, any day after 19th of August.
24th July তে বলবে যে ও নেই সেদিনে আমি অর্ডার করে দেবো আবার কি মেনশন on 24th July you mention I will fix a date for
grateful, my lord. I'll mention on 24th.
May I permitted to mention one matter, my kindly grant a leave for filing wakalat number in the testamentary department, my lord. Earlier I mentioned this matter, my lord asked me to mention today, my lord.
leave দিয়ে So you filed an application for revocation.
Yes, my lord.
Fine.
Your Lordship, may I be permitted to mention this matter? Your Lordship, we have received the change brief from the erstwhile advocate, and the amended application was filed and it was allowed by Justice Shugata Mojumdar. And after that, the department has found some discrepancies that we do not know about. So, Your Lordship, can you can this be put under the heading to be mentioned as per Your Lordship's convenience?
What for?
For hearing, like
Hearing?
under to be mentioned, can this be put?
Why under to be mentioned?
We have to we have to see what the discrepancies that have been found by the department that
Not
we're
been
not
indicated
aware
what
of.
are the discrepancies?
No, Your Lordship, we're not.
Find out from the department, then mention.
Okay, Your Lordship.
Ascertain from the department what is the discrepancy.
Grateful, Your Lordship.
Come.
Original side daily list, commercial bench, item number 1.
I am for judgment letter number 2, my lord. It's my application.
Who is for the decree holder?
Not appearing. I'm appearing for judgment letter number 3.
Yes.
My lord, this is an application preferred by me, my lord. Essentially under section 47 of the Act. The case in a nutshell, my lord, is that the decree holder had obtained a decree essentially in respect of my shares, which is the judgment letter number 2. I am Grasim, my lord. So the decree holder obtained a decree pertaining to the shares which were held by the judgment debtor number 1 in judgment debtor number 2. So the fight essentially was, my lord, between the decree holder, judgment debtor number 1 and the judgment debtor number 3. The prayers also, my lord, in the plaint were crafted essentially against the judgment debtor number 1 and the judgment debtor number 3. The suit is the decree is passed ex parte against judgment debtor number 1 as well as judgment debtor number 2. The only contesting defendant was the judgment debtor number 3 in the suit. Now, after the decree is passed in 2007, the execution is being filed by the judgment debtor in 2021 on the pretext that the decree which was passed in his favor is essentially a perpetual injunction which allows him to put it up for execution at any point of time that he wishes to put it out. Now, in so far as those facts are concerned, there is no dispute. Now, in an application which was preferred by the decree holder, essentially contemplating of putting a certain amount of money, which was provided by the court in the decree to the judgment debtor, the court has essentially gone and passed an order by virtue of which now the judgment debtor number 2, who was essentially persona non grata insofar as the disputes are concerned, has been asked to pay costs to the decree holder for the fight essentially which is mainly between the decree holder and the judgment debtor number 1.
Any opposition has been filed by the decree holder?
Yes, madam.
Yes, ma'am.
You are for decree holder?
Yes, madam, for the decree holder, my lord. My lord, I'm ready to make my preliminary submissions on this, my lord. Just one prayer, my lord. I'm led by Mr. Jishnu Chaudhary in this matter. He's indisposed, my lord. He's come down with fever. As on today morning, we've come to know he's not in court. I'm just praying, my lord, if this can be pushed over to another, my lord, next week. In that case, my lord, he'll be here to make submissions before your lordship.
Reply, you have filed a reply?
Yes, I would like to file the
Opposition to
My lord, if I be permitted to file the
Where is the
affidavit in
opposition?
reply.
My lord, I have filed my opposition, my lord. My lord, my
It is-
advocate on record will be here, my lord. She's coming with the copies. But I'll file it within the course of the day, lordship. It is ready, my lord, because I have the copy with me, my lord. So the original copies, my lord, it is with my advocate on record.
How can I pass the order now?
My lord,
How can I pass the order without the opposition? Where is she?
my lord, she's on her way, lordship, my lord. If it can be passed over, my lord, I can file it.
So wait for some time. Huh? উনি এসে গেলে না অঞ্জন বাবু ওটা এসে গেলে দিয়ে দেবেন অটোগ্রাফের ডেট
Original say regular bench item number 1.
Well, this matter is appearing at our instance. This is an execution application in which an order had been passed appointing, my lord, a special officer, directing him, my lord, to collect the rents, issues, and profits of the joint family properties and putting the respective parties in possession. For some reason, my lord, which we shall come to later on, it has not been possible. This matter has to be gone into
CS execution হচ্ছে কেন to be mentioned থাকলে এটা মান্থলি আরে রেগুলার এটা কোথায় আজকেরটা কোথায় এখান থেকে এটা তো আছে এক্সিকিউশন বলছে
Paprika suit. Suit of 2010.
No, this is not the execution.
Partition suit.
Oh.
The special officer has been appointed.
This is not execution proceedings.
Yes. My lord, what has happened is an order has been passed in the execution proceedings.
Okay.
But for some reason, which we shall have to point out to your lordship, my lord, that order has not been able to be carried out. This matter appeared on a previous occasion before a coordinate bench which had jurisdiction at that time, and the special officer was supposed to file a report. That report, I believe, has not yet come in. Well, irrespective of the report, all that I was praying is, let this matter be fixed any day next week, subject to my lord's pleasure on Friday week. Well, we shall file a supplementary affidavit to place on record the subsequent events. And my lord, there can be an observation that the special officer may also file his report if he so desires. Mr. Jishnu Chaudhary was appointed special officer, but I just heard in the previous matter that he is ill.
Well, may I hand up the last order? Subject to correction, this is not an execution case.
This is not an execution case. This is
So we had taken out an application, but it was my lord will be able to see from the nature of the order passed that it was in the nature of an execution. Be that as it may, my lord, let the matter appear in the list. We shall make our submissions that day. Friday week, my lord.
Is he reading a for filing a report by the partition commissioner?
No, there was no such order. But my lord, I believe the special
officer was appointed to hold a commission.
Yes, we do not. My lord, it was not successful because of the attitude of one of the parties. But those things, my lord, will have to see after going through the orders. Since today it is appearing as marked to be mentioned, I don't want to trouble your lordship today. Let the matter appear marked to be mentioned on Friday week. And my lord, kindly give me leave to file a supplementary affidavit to place on record all that has happened since the passing of the order.
Who is for the defendant?
I'm appearing for some of the defendants.
These are the only appearing parties.
My learned senior friend is also appearing for some of them.
7, 8, defendant number 6, 7.
Okay, you have allegations against which of the defendants they have not allowed? Not said.
1 and 4.
My clients.
Okay. Mr. Utpal Basu, learned senior advocate, appearing on behalf of the plaintiff, submits that the partition commissioner cum special officer is yet to file its report. he intends to file a supplementary affidavit.
To place on record the subsequent events.
In order to place on record some subsequent events. Leave granted to file such supplementary affidavit. Let such supplementary affidavit be filed within
Thursday, my lord, next Thursday. And let the matter appear on Friday.
within a week. A reply thereto, if any.
Lot of point. Just not appearing for respondent number 3, my lord. That could be recorded in the order.
ठीक है, शीतल जी।
Already been recorded. No. Filed within a week thereof. Is this matter after 2 weeks? None appears on behalf of the partition commissioner, special officer, come special officer. The period to file report is extended till the returnable date. Please, this matter after 2 weeks.
Grateful, very grateful.
This matter is appearing under the heading to be mentioned. It দিয়ে দিন এগুলো অত আছেই লিস্টটা থাকে
Grateful by yes.
অঞ্জন বাবু
Item number 2.
Item number. My lord, this is a PLA matter. In this matters, caveator with the permissions of the Honorable Court Justice Arindam Bhattacharya, Arindam Mukherjee, the caveator has been filed caveat petitions, but after the lapses of time, and in such case, right now we want to file a supplementary affidavit. With the permissions of the court, due to the main petitions, there are mistakes in 3, 4, and 5 paragraph, and the nomination regarding the nominations, there is a 2 nominations is not mentioned here. 1 nomination has been cancelled, and regarding the assets of the flat, and for such reasons we want to file the supplementary affidavit.
You are appearing for whom?
I am appearing for Leela Banerjee, petitioner. We have served up notice also the caveator advocates. Learned Honorable Justice
mentioned the matter. Who mentioned the matter? Whose instance the matter has been listed?
We are mentioning, my lord.
They have filed their affidavits. Affidavits are complete.
Affidavit of service, supplementary affidavit we want to file right now. We have served the notice also.
Caveator has filed its affidavit.
Petitioner.
Caveator.
Caveator, yes, they have filed, but after lapse of time, it is need to file within 3rd January or 15th January, but they have done it in February 16.
And publication to the caveator. Asunda, this matter is appearing under the heading to be mentioned. None appears on behalf of the caveator. Learned advocate for the petitioner is directed to serve a notice to the learned advocate for the caveator.
My lord, we have served already.
intimating the next date. This matter on this matter is appearing to be mentioned. Next week is Friday.
Next Friday.
Next Friday.
Notice sir করতে বলেছে advocate petitioner
কিসের under testamentary matter?
yes ঠিক আছে করে দিয়েছি
এসে গেছে
Passable matter item number 1 of commercial bench.
চলে ওটা কথা থেকে 500 বার হয়ে যায়
Affidavit of opposition.
Affidavit of opposition filed on behalf of the decree holder is taken on record. Affidavit in where is the reply? Yes, affidavit reply. Opposition filed by the judgment dated number 3.
2, my lord.
2 is also taken on record. Ms. So-and-so, learned advocate for decree holder, seeks accommodation. This matter appear in the list on Anjan Babu. 2 weeks. 2 weeks.
My lord, 1 week will be fine, my lord.
Yeah. Monday the next Monday.
30th July.
কবে আসছে?
My lord, if it can be kept on 31st instead of 30th, my lord.
31st. যখন তো
তাহলে Thursday রাখুন। 30th I am in some difficulty. 1st August.
1st August. 1st August.
Grateful.
Grateful, lordship.
Item number 3 of regular bench.
But I'm appearing for plaintiff number 4B. Last occasion, the matter came up on 4th of July. The Lordship had directed the application to be served to me. It has not yet been served, my lord.
My lord, I have served all. The affidavit service is with my clerk, and he's coming with the affirmed affidavit service. So we have
served now in court. Right
no,
now.
no,
That is an
extra copy. That is an extra copy. That has already been served. Just show it.
My lord, it was not served on me. It's,
No,
just got it in the order that advocate of the plaintiff number 4B. The order records that. Learned advocate for the plaintiff number 4B submits that the copy of the application has not been served on him. Learned advocate for the applicant is directed to serve the copy of this application on the learned advocate of plaintiff number 4B.
Correct.
We have been there for a long time. It has not been served. My advocate is here, my lord. On instruction.
Not on that.
Definitely not upon the advocate, but we have served it to the person concerning, and now it has been served. This is
it has been given now in court.
Yes. So, if they have any objection,
who will conduct the hearing will come up to the court and say that, sir, it has been sent to my client.
no, my lord,
That's why I mentioned in the order that you serve the learned advocate. So that
I bow down to your lordship. But the thing is that is also with my clerk and the juniors. I have not checked it. That's all. But if they have
now, sir, you have been given, Mr. Sen.
I have just been given, my lord.
I find that the application is not in terms of the original.
Okay.
They are asking for.
You are representing whom?
I'm plaintiff number 5 and 6. 5 and 6.
5 and 6.
Application for substitution.
Amendment.
First title has to be amended. They have to annex the proposed amendment in red ink. That will be carried out by the department.
Yes.
So otherwise, the lordship order will not be effective. That's what I want to say. How will the amendment be carried out until and unless they have shown it?
Yes, my lord. I also, my lord, I agree with my learned senior here, my lord. Issue an order to substitute.
The applicant.
Master
so, no prayer also for amendment of the first title.
master summons?
application করে দিয়েছে।
I'm also taking that point that it should be by way of master summons and affidavit, but still.
এটা কি করেছে? My lord, it's the cost title also I think is wrong.
That is a
In the High Court and writ jurisdiction.
no, that is a typo Calcutta. That's the error.
But that will be required, no?
That's a entirely typo Calcutta. I've seen it.
Page of the application.
I've seen it.
Writ jurisdiction, my
This is
lord.
not,
Is a
Read jurisdiction.
this is not proper. Your lordship should not take it on the record.
cost title is itself wrong, my lord. The cost title has to be the same as in the, my lord, in the plaint, only with the GA number on top. They've given an application for substitution. This cost title is not in this manner, my lord.
This application should not be on record.
Cost title তো সেমই দেওয়া আছে।
I think you have to withdraw this application, file a fresh application then.
This application nothing can be done.
There are certain defects.
There are some defects. Because in
Certain
the
defects you have
at the
not
heading
arranged.
it is defected.
The copy of the amended that has also to be.
Yes, it is my responsibility, my lord. I am to see all those things. I have not seen it.
What
It
you
is-
going to withdraw this application?
I'm withdrawing it and then I will file it fresh.
Mr. So and so, learned advocate for you are representing
Applicant,
applicant.
that is
Submit
in the
that there are-
original suit,
Applicant GA 49.
GA 49, applicant of GA 49, madam.
Submit that there are certain technical defects in the application. He seeks leave to withdraw such application with liberty to file afresh. The application stands dismissed as withdrawn with liberty to file afresh.
File afresh. Grateful.
Oblige, my lord.
Item number 4. I beg to appeal on behalf of the Kolkata Municipal Corporation.
I do appear for the party in the suit, my lord. This is a matter, my lord. You would recall, my lord, this matter pertains to their old dilapidated property at central Kolkata, my lord, where a report came from the Kolkata Municipal Corporation that the building is in a dilapidated, ruinous stage, my lord. Now, pursuant to the report, my lord, we took an instruction what to do next, whether to preserve the building or to sell the building, my lord. Now, we have taken out an application, my lord, for a direction to sell the property and distribute the share, my lord, amongst the party. Service is on the process, my lord. My lord will keep that matter, my lord, any day, my lord, in the next week, my lord. I hope, my lord, by that time we will be able to complete the service. My affidavit of service is also ready. I will give your lordship the number, IA GA number 10 of 2023. 2024, 2024. Let that be listed, my lord.
আমাকে ওটা কপি দিয়ে দিস।
Yes, certainly. IA GA number 10 of 2020.
What is 9?
9 is that application, my lord, in which, my lord, the special officer was appointed, and, my lord, as Kolkata Municipal Corporation was directed to make an inspection of the property and file a report before the court according.
Okay.
That.
Okay.
Let this GA appear, my lord, any day in the next week, my lord. I hope, my lord, by that time, my lord, the service would be complete, my lord.
Mr. Meghnad Dotto, learned advocate for the plaintiff petition, plaintiff, submits that his client has taken out an application being GA 10 of 2024, which requires to be listed. List GA 2024.
10 of 20.
Copy, you have given a copy of GA.
I have not yet received.
Although the Kolkata Municipal Corporation is not a party to the suit, if my lord so directs, my lord, we can certainly give a copy to the Kolkata Municipal Corporation, my lord.
Give a copy.
Certainly, my lord. Give a copy to them. My lord, the GA is before the court. It has already before the court, my lord. Let it list it in the next. It has appeared.
Grateful, my lord.
We will give up.
Next.
Item number 5.
My lord, in this matter, my lord, I do appear for the one, my lord. Now this suit,
Here in this matter, I am appearing for the plaintiff, my lord. On the last occasion, your lordship had given me direction to take instructions with regards to an application filed by the defendant for seeking recalling of the order wherein the matter was made undefended suit, your lordship, and the arguments had commenced in this matter, my lord. I have taken instructions with regards to the application, your lordship. There is no scope of any interim order. Therefore, we would like to file an affidavit in opposition to that. And your lordship, there was another direction with regards to the receiver furnishing a report with regards to the accounts that was in pertaining to the partnership firm. The disputes are arising with regards to that partnership firm, your lordship. Mr. Somnath Roy, advocate, was appointed.
Receiver is present today.
my lord, the receiver report is there, my lord, but no one person is there to present the report. If my lord permits me, then I can present the report.
No.
Of the report, my lord.
The receiver?
Mr. Somnath Roy.
My lord kindly directs us to the plaintiff to serve a notice upon them on the next question for them to be personally present and handed over, your lordship.
Okay.
Report is ready. It's if my lord wants gives me a liberty, I can present it.
You keep it. Mrs. Orunima Lala, learned advocate for the plaintiff, seeks to file affidavit in opposition to the application being GA 13 of 2024. Let such affidavit in opposition be filed within
2 weeks, your lordship.
weeks. Reply there to Mr. Dotto.
One week, my lord. One week, my lord. My lord, just one thing, my lord. This filing of affidavits will take 4 weeks. Thereafter, the my lord will decide the fate of the application. If Ms. Sengupta is agreeable, my lord, we can cut down the matter, my lord. 1 week undertaking I will give, and within that period, my lord, I will complete the cross-examination and we will commence with the arguments.
We are not agreeable to that, your lordship. Kindly allows us to file an affidavit.
Let them file it.
Let them file it. I don't want to prolong the matter. Since there's a delay, I don't want to prolong the matter.
Mr. Dotto, learned advocate for the petitioner, informs the court. Shall I record your submissions that the receiver's report is ready?
Yes, yes.
Submit that the report of the receiver is ready. It is found that the receiver is absent. Learned advocate for the plaintiff is directed to intimate the learned receiver of the next date of hearing. Please this matter 3 weeks. In Shaptabod, after 3 weeks.
My lord, record my submission also that with I can give an undertaking, but within 1 week, 1 month, I will complete my.
No, I'm not recording that because since they are coming up with an opposition, this application should be heard.
That will delay the matter, my lord. I don't want to delay the matter, my lord.
I know. In last day also, you submitted that.
Yes.
You give an undertaking and process.
1 month undertaking.
But he is not agreeable to a submission.
Now, that will delay the matter. I don't want to delay the matter. Since there's a delay, I don't want to.
Let us hear out the matter. No, application. Next.
Want to the suit on merits, my lord.
My lord, the is after 3 weeks.
3 weeks.
Grateful.
Item number 6.
Lord, I appear on behalf of the petitioner. But the instant suit was being heard analogously, my lord, with another suit being CS 100 of 2009. My lord, only the CS 268 of 2007 is the only one which is appearing in the list today.
What is the other suit? 100?
Yes, my lord. Parties are same, my lord. The cause of action is same, and the dispute also pertains to the same property.
That is also to be listed. What is the stage of the suit?
My lord, the stage of the suit, my lord, was for inspection, discovery, and disclosure of documents. For that, an application had been taken out, my lord, as well as a prayer in the same application was also made for appointment of an advocate commissioner for taking the evidence, the examination in chief, as well as the cross examination.
GA 9 of 2016 is for?
My lord, that's the application about which I was just intimating.
Leave has been granted. That is disposed
The
of.
leave was granted, my lord, to file the affidavit of documents for inspection and discovery. So the documents were filed, my lord, served also upon the advocates of the defendant, call for inspection, but the inspection discovery part has not been completed yet because the advocates for the defendants didn't come and take inspection of the documents. Very good. Insofar as the other prayer was concerned, my lord, that was not allowed and the application was disposed of.
What is your submissions today? That 100 is to be listed along with this?
Yes, my lord. That's one. Second, my lord, I was humbly praying in terms of the Commercial Codes Act. This is a commercial dispute, my lord. So both the suits essentially can be converted into the commercial determination subject to your lordship's
Who is for the defendant?
Mr. Shomdeep Dotto, my lord, was originally the advocate on record for the defendant, my lord.
Both the suits will be converted to the commercial division.
Yes, my lord.
Both suits.
Both suits, my lord, because both commercial codes.
Arjun? CS 268, what is the prayer of 268? It is for?
Just a minute. But it was essentially for a declaration that the defendant would not be entitled to operate the printing machine which it was stated to install at the premises of the plaintiff. So the prayers in the plaint insofar as CS 268 were concerned, my lord, is decree for declaration that the defendant is not entitled to install any new plant or machinery within the demise premises, particularly described in schedule being annexed A to the plaint, excepting by way of replacement of the existing plant and machinery. Decree for declaration that the defendant is not entitled to install any additional or new plant or machinery and or to construct any new foundation, therefore, within the demise premises as described in the schedule being annexed A to the plaint. Decree for perpetual injunction restraining the defendant, its servants, agents, and or assigns from proceeding any further with the installation of any new plant or machinery within the demise premises, particularly described in the schedule being annexure blank to the plaint and particularly on the eastern side of the demise premises. decree for perpetual injunction restraining the defendants, its servants, agents, and or assigns from installing any new or modern plant and machinery within the demised premises, particularly described in the schedule. So essentially, my lord, the prayers in CS 268 relate to the installation of a new Heidelberg machine, my lord, which was supposed to be installed.
Yes. And 100?
And CS 100, my lord, is the eviction suit. So over there, a prayer has been made, my lord, for eviction.
So how this is a commercial suit?
My lord,
then again, after conversion into commercial, the witness action and discovery all will be done as per the Commercial Courts Act.
my lord, it's only a formality insofar as that statement of truth and affidavit and all are concerned. The documents which have been disclosed, we only need to basically convert that into the commercial courts format, my lord.
Okay. অঞ্জন বাবু ওই কনভার্সন জন্য কোনো অ্যাপ্লিকেশন ফাইল করতে হয় নাকি ও অ্যাপ্লিকেশন ফাইল করুন আর লিস্ট করে দিন 100টাকে লিস্ট করে দিন মিস্টার you are Mr. Ghosh?
Yes, my lord.
Mr. Pratik Ghosh, learned advocate for the plaintiff, submits that the present suit was appearing along with CS 100 of 2009, which also needs to be listed along with this suit. List ওইটা পরে দিচ্ছি কেটে দিন none appears on behalf of the defendant. File an application for conversion of these suits into commercial. Mr. Ghosh?
Yes, my lord.
File an application.
Generally, it's not required, my lord, if that's what your lordship says.
He submits to take out an application for conversion of the suit under commercial division. List CS 100 of 2009 along with the present suit. Learned advocate for the plaintiff is directed to intimate the next date to the learned advocate for the defendant. There is only one defendant?
Yes, my lord.
Okay. List this matter after 2 weeks. But then all these years you did not intend to convert this application.
I'll just give a brief prelude into that, my lord. We had preferred an application under Order 12, Rule 6 in CS 100. My lord, the primary dispute between the parties here is the premises in question. There has been a construction of a 24 square meter concrete block. Now, according to us, we say that's a violation of the covenants of the lease. And in terms of that, you are entitled for, that is, the plaintiff is entitled for a decree for eviction in terms of Section 108 MNOP, because that was not something which was being given under the original lease. So on the basis of that particular admission being made by the defendant in the instant suit, which is CS 268, we had preferred a judgment upon admission in our suit, the other one, which is CS 100, which was subsequently filed and being heard. There was the trial court initially had passed a judgment in our favor, allowing the application under Order 12, Rule 6. Now, that order was subsequently set aside by the division bench and also confirmed by the Supreme Court. Now, all this thing took some time, my lord, and ultimately the Supreme Court gave its view in the matter just prior to COVID in February 2020. The Supreme Court also gave us liberty to file an application seeking for urgent hearing of both the suits. Now, it's my personal opinion, my lord, that insofar as CS 268 is concerned, there is nothing left in that suit. But howsoever, I don't have that call to basically make at this point of time to whether pursue or not to pursue. Appropriate instructions have been sought from the client, my lord. So if we intend not to proceed with CS 268, because for all material purposes, they are operating the machine in terms of a court order, which essentially, my lord, is GA9, and they are running that particular press also. So essentially, CS 268 as on then has become infructuous. So there are no other prayers which I can seek for in CS 260. The only suit which remains of consideration is the eviction suit. So till I get sufficient instruction from the client, my lord, I can't come and make that submission. So this was a personal view which I had made. So that's why we couldn't get this thing converted into a commercial suit. Your lordship has given us the liberty to file an application to that.
Yes.
Grateful.
কবে করছেন? ঠিক আছে, সেপ্টেম্বরে বল, সেপ্টেম্বর monthly list. We are fixing it on monthly list of September. In the meantime, you file application. That will do. Or I will also get the instruction whether to continue
Yes,
268 or not.
we'll do so. Thank you.
Item number 7.
My lord, I appear for the petitioner, my lord.
Item number 7, I am the receiver in the case, your lordship.
My lord, on the last occasion, your lordships directed the department to carry out the report filed by the special officers, which has not been served upon the petitioners. Now, one of the special officer, as I indicated, my lord, on the last occasion has shifted to Delhi. Now, he is present in Kolkata. He is Rahul Sengupta. Saurabh Ghosh and Rahul Sengupta was appointed as Saurabh Gupta and Rahul Sengupta has been appointed as special officer receivers. Saurabh Ghosh has shifted to Delhi, Saurabh Gupta, and he is present in Kolkata. Now, my lord, on the last occasion, your lordships gave some time before to the department to search out the report because that was not found.
পাওয়া যায়নি বলে তো হবে না, কিগুলো তো আপনাদের কাছেই ছিল। কি আপনাদের কাছে রিপোর্টস বলছে কি আপনাদের কাছে, আপনি ডিসপ্লেস করবেন কেন? অর্ডার্স গুলোতে তো বলছে আপনাদের কাছে কি ছিল, প্লাস রিপোর্টটা কোথায়? পিটিজি আগে রিপোর্ট, রিপোর্টটা কোথায়? When did the keys of that locker was handed over to the department?
Lordship, to honest, the report was submitted in December 2013 before Honorable Justice I.P. Mukherjee, and we submitted the keys along with the report in the envelope to the before Justice Honorable Justice I.P. Mukherjee. And the Honorable Justice Api Mukherjee was pleased to ask the receivers to file the report, and we submitted the keys therein only.
In the court?
In court.
My lord, may I humbly beseech one thing, my lord? My lord can give direction to this special officer to go and in the presence of the branch manager of the bank, in the directions of this high court, he can break open the lock, he can take out the articles, he can submit a report before your lordship so that the articles can be handed over to the executor for proper distribution. Because LA has been granted, my lord, in the year 2016, my lord. Your lordship passes an order, he can go and do the needful, my lord.
But then as per your prayers, you have sought for opening of the locker, not for breaking of the locker.
My lord, in the event the keys are
that
not.
you were in the you were of the idea that the
Yes, my lord,
key
because
was lying with this.
yes, my
There
lord.
was no occasion to pray for opening of the locker.
And the report, as they have, and the special officers say that they have filed a report. That report is also not with us, my lord, because there were no direction to serve the report on the petitioner. This matter is pending since 2016. My lord can direct the special officer to go and open the locker in the presence of the branch manager and take out the articles, my lord. So that he can be discharged.
Awesome. This is an application for opening locker number 37 with key number 138. In State Bank of India High Court Branch, Kolkata, connected to savings account number 3349-844-8508. And locker number 4/11/09. Both are different banks, two banks, two different lockers.
No, my lord. My lord, the directed to open the said lockers being locker number 37 with key 38. Yes, my lord, two bank accounts, my lord, two bank accounts. Two bank accounts. One is Punjab and Sindh Bank.
The keys were given to the
Only one bank account keys were given to the lordship. We went to the State Bank of India, Kolkata branch, and we submitted the keys before the court.
What is your prayer? Which of the bank locker is to be opened?
My lord, the directions is, my lord, I see the prayers as there, my lord. State Bank of India locker has to be open, my lord. They were appointed special officers, my lord, in respect of the State Bank of India locker.
Not the other one.
No, my lord.
You have annexed the order of their appointment?
Yes, my lord.
Order dated?
My lord, page 18, my lord. The 1819, my lord, I appoint Rahul Sengupta and Saurabh Gupta to take possession of the same, remove and keep them in a locker to be hired by them in State Bank of India, High Court branch, Kolkata. My lord, page 19. The order dated 29th November 2013.
Okay. Then what about the other lockers?
My lord, I think, my lord, this is a typographical mistake. It has came into the prayer, my lord. But as far as the receivers are concerned, my lord, they are only concerned with the State Bank locker. My lord can give direction regard to the State Bank locker only.
Account number this. No, second and order. On paragraphs. On 3rd July 2024, it was reported by the section officer Testamentary Department original site that in spite of vigorous searching, the reports of the joint receiver and the key of the locker could not be traced out till date. The section officer sought for some more time for tracing out the reports and the key. Mr. Rahul Sengupta, learned receiver, is present in court. He submits that the report and the keys of the locker number 37 lying in State Bank of India High Court branch Kolkata was furnished to the court. नाम टा की उन्हीं के सेक्शन ऑफिसर the assistant registrar original site is present in court and he informs that the reports and the keys are yet to be traced out. At this stage, Mr. Dhilon Sengupta, you are Mr. Dhilon?
Yes, ma'am.
Learned advocate for the petitioner, submits that order be passed for breaking open the locker number 37 in presence of learned advocate for the petitioners as well as joint receivers.
My lord, I'm sorry, my lord, one submission. My lord, I am one of the joint receivers who had shifted to Delhi, my lord. My lord may just clarify that since I have shifted to Delhi, my lord, I cannot be physically present. However, I have no objection. Mr. Sengupta on my behalf does the needful, my lord.
So both of you are discharged.
Obliged.
Both of you are discharged.
My lord, after they comply with the direction,
They cannot be because he cannot come.
My lord, he can do because he has no objection.
If he continues.
If he continues, my lord.
No, my lord is discharging me. I have no objection, but the problem is physically I cannot come to Calcutta because of my duties before the courts in Delhi, my lord. I'm serving as an advocate on record in Supreme Court, and it's not possible for me to travel down to Calcutta, my lord.
Then again, a new receiver is to be appointed.
If that can be done, my lord, will be the best.
My lord, may I suggest, my lord, if he has no problem in carrying out the duties by him, he can do the duties and thereafter both of them can be discharged, my lord. My lord, he has given a letter to us.
The court previously passed order appointing joint receivers.
Yes, my lord.
Now one of the receivers could not come and he cannot give a consent to the other receivers to go and hold because there is a direction of the court that inventory is to be made by both of them.
Yes, my lord. Inventory has been done by both of them.
Now, with regard to the listing of the articles of the locker, if he is not present,
my lord, they have prepared a minutes, my lord, which we have annexed, my lord. They have the items lying in the they have the chart of the items lying in the said locker, my lord. That he can go and do the needful, my lord. And he has expressed his no objection in doing the needful by this Rahul Sengupta, the other special officer, my lord.
You will know the joint receivers in presence of the joint receivers. Mr. Saurav Gupta, the other other receiver, through virtual mode, informs of his inability since he is now practicing before the Honorable Supreme Court, of his inability to remain present. In the aforesaid backdrop, let the locker number 37 in State Bank of India High Court Branch, Kolkata, we break open in presence of the manager, State Bank of India, as well as Mr. Rahul Sengupta, receiver, one of the joint receivers, and the learned advocate for the petitioner. Mr. Rahul Sengupta shall submit a report of the list of articles the bank manager, State Bank of India High Court Branch, Kolkata, shall extend all cooperation to the receiver for doing the needful as aforesaid. This matter after 2 weeks. Mr. Gupta, not now.
Yes,
Let me
lord.
Gupta hold the inventory of the articles of the locker after breaking it open. He will file
Yes,
a.
I have no objection if Mr. Sengupta does the needful, my lord.
Okay.
As my lord is already directed.
Note করে দিন যে he has no objection. Mr. Gupta যেখানে submission করছে, he has no objection if Mr. Sengupta carries on the duties of the receiver for holding inventory. What are the articles those are present in the locker?
My lord, we are not aware.
You are not aware. Okay. After 2 weeks.
Obliged.
Obliged, my lord.
এটা কালকের তো কালকের
Item number 8.
Yes, my lord, I am appealing for the. This is a restoration application, my lord. On the last occasion, lords, on 3rd July, my lord passed an order in. Oh, yani? There were twice this was dismissed. First, this was dismissed on my lord 29th of March, and after that, G number 3 was taken out. Thereafter, the same was also dismissed on that is on
it is
13th February 2024. My lord.
Papers to আসেনি নাকি?
On the last occasion,
আচ্ছা ঠিক আছে তাহলে ঠিক আছে it is
on the last
by
occasion,
order dated 3rd July 2024 direction was issued for listing GA3 of 2024 along with this application. However, it is informed that due to some technicalities, the same could not be listed.
I have the copy of the
list GA3 of 2024 along with this application on Monday, 22nd July.
Lordship is again fixing on 22nd July. Yes.
Item number 9.
Lordship,
For the respondent,
Lordship, this is my application for revocation of probate, Lordship. This is the last order,
we had
Lordship.
been directed to
Final
file an
application.
to bring on records certain documents, my lord. We had the application affirmed, my lord, certain defects were detected.
Lordship,
when this court grants us 1 week's time, we'll file
Lordship,
the application.
kindly go to the last order, pass the Lordship. Lordship, this has been going on since September 2023, Lordship.
For which such transfer trade forms. Seek to remove finds an application in terms of
Lordship, given time till 1st of July, Lordship. Today we are on 19th July, Lordship. 18th July, Lordship.
Defects were detected. We have rectified the defects. If it can be kept 1 week later, it will be my lord. We will comply with my lord's order.
Lordship, may I kindly hand over another order, 21st September 2023, Lordship, from where since it has been started, Lordship, that they have been praying for time to file, bring on the documents on record, Lordship. Since 21st September 2023, we are in July, mid of July, Lordship.
GA1 of 20, you are the application?
Lordship, I'm revocation application, Lordship, for probate. Lordship, since September 2023 till July, Lordship, nothing has been, affidavit has been complete, Lordship. After that, they have been praying for supplementary affidavit. And for that, Lordship, it has been there.
We had prayed for a supplementary affidavit. Court had directed us to take out an application. Admittedly, my lord, we have been unable to file the application. Certain defects were detected. Once the defects were detected, we have rectified the defects, my lord. If it's kept next week, we'll comply with the court's order, my lord.
It should be served upon the
Lordship, kindly
Okay.
recall, Lordship has said this is the last chance, Lordship. Kindly recall, Lordship.
So, learned advocate for the respondent seeks accommodation to seeks again submits that there has been some defects in the application which has been removed and will be filed shortly. He seeks for you have filed it or about to file?
But we are about to file it.
About to file it. Okay. In terms of order dated 6 May 2024. He seeks for accommodation of 1 week. Release this matter after 1 week.
Lordship, kindly make it preemptory, Lordship. Lordship, this has been going.
Matter after 1 week. Huh?
Lordship, kindly
File the application.
Yes, my lord, it will be done.
And also give a copy to
Yes,
the
my
other
lord.
side.
Lordship, kindly make it preemptory, Lordship, since September, Lordship.
Yeah, I've heard you. Let them come up with the application here.
Item number 10.
No, this is my application seeking amendment, my lord, of the affidavit of assets. My lord, this is, my lord, relating to a testamentary suit. My lord.
Yes.
So we can cut it short. I'm not opposing the application. There was a direction on him to incorporate
a locker.
the locker particulars without actually going into whether the locker particulars are right or not. That's on the merits of the amendment. But he can file the application can be allowed. Only other thing, my lord, that there could be orders for discovery and inspection of documents. There is that's all. Because there's also direction for expeditious disposal of the trial of the suit.
Very well.
Just that much.
Thank you. But can allow that, my lord, it was, my lord, directed by, my lord, this court by an order dated 21st of May 2024. My lord will find at page 10. The relevant part is at page 18. Where, my lord, I was directed to, my lord, include the locker. Paragraph 12 of the order. My lord, I have accordingly, my lord, included it. At, my lord, page 10, the order starts. My lord will find at page 18. Paragraph 12, it starts. Where, my lord, this court had directed, my lord, that paragraph 13, the bold paragraph.
13.
I further direct the executor on his mother and such and not to operate such and such and dispose of the contents. And prior to that, I'm sorry. As the locker stood, my lord, page 18, yes, I direct the executor to incorporate the particulars of the locker in the affidavit of assets by making necessary amendments. So, my lord, I had to take out this application seeking, my lord, the amendment of the affidavit of assets. My lord will find, my lord, my affidavit of asset is at page 47. It starts, and my lord, I've included it at my lord, paragraph at page 51, Roman 5. I've included the locker pursuant to the direction. So, my lord will, my lord, accordingly, my lord will pass, my lord. Yes, 49 my lord, is the prelude, my lord. Why, my lord, I have to include? I have given the gist of the order passed by this honorable court. It starts from 49, paragraph 5A, 5B at page 50, and page 51. And 57 is the total amount which has increased.
Awesome. This is an application for amendment of affidavit of assets. Mr. So-and-so, learned advocate for the plaintiff, submits that pursuant to order dated 21st May 2024, this application has been filed for incorporating the particulars of the locker in the affidavit of assets. Stop. That has been filed. He seeks for order in terms of prayer.
Prayer A to C.
A to C of the master summons. Mr. So-and-so, learned advocate for the defendants, does not raise any objection. However, he submits that an order be passed for completion of
বলে দিচ্ছি
for completion of discovery and inspection.
Millet, to this Millet only one submission. Only one. I'm sorry, Millet, for interjecting, Millet. Millet, there was a letter by my advocate on record, Millet, inviting the Millet, my learned senior friends, advocate on record to Millet carry out the discovery and inspection. Millet, they have not carried out. Millet, this is only my submission. So, Millet, I had already indicated when this application prior was taken up by Justice Sinare, Millet, we have filed the Millet judge's brief with the department. Millet can record that only. That is filed with the department. That has also been taken note of Millet's predecessor to the chair accordingly.
So general direction is being passed on the parties to complete the inspection and discovery?
No, then the issue is that after the testamentary it's converted, I has to give a notice to them to carry out the inspection and discovery. That has been done. So, Millet, they have not come. They have not come. They have not come. Millet, so accordingly, what document I had, I have filed the judge's brief with the department. That is on record. That is my duty to point out before Lordship. My Lord will pass necessary orders.
Very well. Kindly direct discovery and inspection, then we'll.
Otherwise, Millet, factually it will be wrong on my part.
Mr. So-and-so learned advocate for the plaintiff indicates that a letter has been issued to the learned advocate for the defendant for causing discovery and inspection. However, the same has not been done as yet. What about the inspection of the documents of the defendants? You have done it?
No, Millet, they have not come. They have not come. We have also not gone because.
So it is.
So, Millet, we have filed the judge's brief as on the document we had.
So
that is
pending.
is pending.
Nothing else.
We have filed the judge's brief.
Okay.
Additionally, it has to be done if my Lord allows.
And the judge's
All documents,
brief
including the
has
judge's
also been filed by the plaintiff.
Yes.
In view of the by order dated 21st May 2024, the executor was directed
May I take my Lord's brief?
to incorporate the particulars of the locker in affidavit of assets by making necessary amendments therein. Considering the aforesaid and the amendments made in the application, let there be an order in terms of prayer A to C, A to C of the master summons. The department is directed to carry out the amendment within a period of 4 weeks. The parties are directed to complete discovery and inspection. Within which period you will do that?
in a period of 2 weeks.
This is after the amendment, or in the meantime it can be done?
After the
Within a period of 2 weeks.
2 weeks.
Stop. Affidavit of admission and denial of the document shall be submitted within a week thereafter. Application being GA7 of 2024 stands disposed of.
Very good.
Very good.
Item number 11.
Your Lordship, I am appearing on behalf of the petitioner, Lordship. Lordship, this instant application has been filed for the correction in the affidavit where the religion and the address of the deceased has been wrongly mentioned as Hindu and resident of Calcutta instead of Jain and lately residing at Delhi.
This is an application.
I am appearing on behalf of the propounder, the sole executor in this matter. And my Lord, this is a non-contentious cause. My Lord, the amendment which I am seeking, my Lord, before your Lordship is of a very innocuous and interesting nature. My Lord, the the testator, Mr. the late Fusraj Nahata, he died at Delhi. But by the time we had filed the probate application, Milord, in usual course, we gave the address of Kolkata. But the death certificate, Milord, recorded the address where he had, Milord, last resided, being at Delhi. So, Milord, the department had suggested that kindly carry out the amendment. The second amendment, Milord, is of his religion. He is a Hindu, but he wanted it to be, Milord, specified as Jain. So these are the two innocuous, Milord, amendments which we have suggested. For your Lordship's satisfaction, if your Lordship kindly comes to page 15, and that is the death certificate, it discloses the address of Delhi. If your Lordship, Milord, is at page 15, Milord, a place of death, 209, Kadambari apartment, sector 9, Rohini, Delhi. Milord, this is the amendment which we, Milord, intend to bring in by our present application. And Milord, the suggested amendments are from page 25 onwards. Okay. These amendments are suggested in the application for grant of probate and the several affidavits, including the consentee affidavits which have been filed, Milord, both in the cause title, in the body, as well as, Milord, at the back sheet of each such affidavit. The entire bunch, Milord, we have annexed with suggested amendments. And Milord, it runs from page 20. Our proposed amendment runs from page 25 till the last page of the brief, that is page 103.
This is an application for amendment of the probate petition. Mr. Swansol, an advocate for the petitioner, submits that the instant petition has been filed for changing the address and religion of the deceased in the application, probate application. Okay. He prays in terms of prayer A to C of the master summons. Considering the submissions advanced on behalf of the petitioner and the amendments made in the application, as well as the death certificate annexed to the application, let there be order in terms of prayer A to C of the master summons. Department is directed to carry out the amendment within a period of 4 weeks. GA3 of 2024 stands disposed of.
I'm deeply obliged.
Any.
Item number 12.
I am for the petitioner. My lord, when the original PLA was filed, the contents of the locker were not known to us. Accordingly, the court has was pleased to direct for the locker to be valued by the valuer. And later on, we came to know about the contents of the locker. And therefore, the thereafter, amendment has become necessary in the original petition and the affidavit of asset.
Which paragraph?
The portion that has to be amended, that is marked in reading.
In which paragraph you have stated that at the time of filing of the application, the locker number was not known and subsequently it has come to your knowledge?
My lord, in the original PLA application, in page 6, the amendment is required. In the page 6, where the gross total is mentioned. And my lord, in
What is
page
the amendment
3,
you are seeking in the affidavit of assets?
my lord, in affidavit of asset and as well as in the petition. Only the contents of the locker, my lord, and the gross total. And report of the inventory was submitted by the valuer in the court. And my lord, on 5th January 2023, the Honorable Justice Orinder Mukherjee was pleased to direct us to make the inventory.
The order also. What is that order?
Order dated 5th January 2023, page number 5.
Okay. Now this has been done. The evaluation has been done.
Yes, my lord. And the report is submitted in the.
Where is that report?
My lord, running page number 7, annexure D. I'm sorry, my lord. The annexure A, running page number 7.
Annexure B.
Annexure A. Only one annexure is there.
Annexure A is the order.
Order and the valuation report is also annexed with the order.
This copy, it is marked as annexure B. It's 7. Ujjwala Jewelry.
Yes, my lord, annexure B.
Now this value has been incorporated in the affidavit of assets.
As well as in the petition.
Where is the affidavit of assets?
My lord, it is the annexure D. No, my lord, annexure C.
Page number?
Page number, my lord, running page number 8.
There is no page number 8 here.
Annexure C in page number 8, my lord.
অঞ্জনবাবু কোথায় annexure C কোথায় আছে? B তেই তো শেষ হয়ে যাচ্ছে দেখছি। কেমন?
Page 8. Running page.
Sorry?
And my lord, the portion that has to be amended, that is marked in red ink in running page number 10, page 3 of the affidavit of assets. And also, my lord, running page 13, that is page 6 of the affidavit of assets, the gross total and the net total.
Okay.
And one more thing, my lord, the department may be directed to act accordingly. Act accordingly, accordingly your order, my lord.
This is an application for amendment of the affidavit of assets as well as the probate petition. The application for grant of probate?
Yes, my lord.
Okay. Ms. So learned advocate for the petitioner submits that pursuant to order dated 5th January 2023, valuation of the articles in the locker at Central Bank of India, Ravindra Sharoni branch, Kolkata 740-401 has been made. By the aforesaid order, liberty was granted to the petitioner to amend the affidavit of assets and petitions for grant if necessary. Stop accordingly, the petitioner has made this application for causing necessary amendment in the affidavit of assets as well as the probate petition. Considering the submissions made on behalf of the petitioner and the amendments made in the application, let there be an order in terms of prayer. A to C of the master summons. A to C of the master summons. Department is directed to carry out such amendment within a period of 2 weeks from date. Application being GA2 of 2024 stands disposed.
Much obliged.
Made resolution. I am for the petitioner. This is my application for revocation of grant of probate. The ground is that I am the legal heir, one of the legal heirs of the deceased, whereas in the probate application, they have stated they could not find out any legal heir of the deceased and they published in the newspaper. Wherefrom in my application from the annexure itself, I can satisfy your lordship that we are very much aware of it. They knew that I am the nephew of the deceased. We had a communication. I did the last rituals. The last rituals was done by the petitioner itself. Thereafter, several communications, emails, and WhatsApp communications also been, my lord, done between the parties. My lord, thereafter, surprisingly, my lord, when I tried, my lord, the property was in my possession. My lord, thereafter, they tried to grab the property on by virtue of this probate grant of probate. My lord, though they did not disclose about the probate. In the 144 application, they have stated myself, the opposite party, as a nephew. So, my lord, affidavit is required. My lord, they need to file an affidavit within the shortest period of time so that the property, my lord, the matter can be resolved.
Lordship, I heavily object to whatever statements has been made. The property has not been in their possession. It was in possession of the executor, Lordship. The deceased died sometimes in 2021. Subsequently, the probate application was filed in 2022 and the probate was granted in June 2023. Paper publication was made in January 2023 and they have filed this application in 2024 June. So after all these delay, I can establish and show that there has been no communication. We had no communication in regard to whatever they are saying that there were emails and WhatsApp messages. But after the death of the deceased, there was no communication. We had no knowledge about the heirs also. And it is not denied that there were heirs of the deceased, but we have accordingly made the paper publication and order has been passed. These are the orders, Lordship can see.
May I submit one? My lord, an affidavit is required to be called for, my lord. Because if they do not want to file an affidavit, they want to hear out the matter at right now, then I am ready to contest. If they want to file an affidavit, let us not waste the time of the court and let
Back with the affidavits, Lordship, because whatever the allegation, what has been made in the application, everything is just a statement. there is no corroborative evidence in regard to that.
Well, in that case, let us waste some time of the court. Well, let us waste some time of the court. Let us come to particular only one document. Let us waste some time. I was in favor of not wasting of time, because there are a lot of my learned friends are in the queue, and this is the first day the matter is appearing in the list. That is why I thought the affidavit of direction they will agree to that. My lord, if that be the position, my lord, kindly comes to the communication, the email made to my learned friend's client, the propounder, page 41.
This is an application for revocation of grant of probate. Dated 22nd June 2023 in PLA number 164 of 2022. Mr. So-and-so, learned advocate for the petitioner.
Shoumen Dotto,
Shoumen Dotto, learned advocate for the petitioner, submits that the petitioner was not served with any notice and was not aware of the probate proceedings. Not aware of the probate proceedings. On such ground, this application for revocation has been filed. This is so-and-so, learned advocate for the respondent seeks to file affidavit in opposition. Submits that general and special citations were the general citations were issued. General issued, and the gist of the general citation was published in the newspaper. Thereafter, the probate has been granted. She seeks to file affidavit in opposition to the application for grant of for revocation of the probate. Revocation of the grant of probate. Let such affidavit in opposition be filed within negative within
3 weeks.
In 3 weeks, yes.
On 1 week.
1 week. Is this matter after 4 weeks? 1 week.
Grateful, actually.
I take this order.
I'm appearing, and my learned friend, he is appearing online.
Lordship, it is my application. The mother application is for the application for grant of letter of administration. Lordship, kindly come to page number 8 of my application. By order dated 5th October 2023, Lordship, I have complied this order and special citation was issued. That should kindly come to page number 9. Running page number 2 of the order, where I have been directed to search citation on the legal years. And thereafter, Lordship, kindly come. Lordship, may I continue?
Which page should I come?
Lordship, the order is at page number 8 of the application. Page number 8, order dated 5th October 2023.
Page 7.
It's page 7, my lord.
Lordship, sorry, it's page 7, where it is directed that I should issue special citation on the general citation on the legal years of the deceased. And I have complied.
Copy the report. Special issue. Yes.
Lordship, thereafter, upon compliance, kindly come prior to that page. It is a report by Sheriff Office. Sheriff Office. Lordship, at the bottom, it is recorded that on 5th day of January, 3 undelivered packets with postal remark UC. UC, the full form of UC is unclaimed.
Page number, where are you reading?
It's at page 9, my lord. Page 9.
Yes, UC.
Lordship, at the bottom, it is recorded that is 3 undelivered packets with postal remarks UC. UC full form is unclaimed. Unclaimed. So on account of unclaimed envelope, it is pretended, it is next question of law, that is whether it is a good service or not. So in avoid to this contingency, Lordship, I am taking this application and pressing the prayer A only. Of master summons.
Okay.
I need, Lordship, 4 weeks time for the publication because the citation to be issued by the department. Thereafter, I can make the publication and need to make affidavit of service.
Mister, this is an application for issuance of special citation and publication of the copy but the special citation was once issued by the order of this court.
Lordship, absolutely correct. Prior to that, special citation was issued in the form of speed post.
Okay.
In the form of speed post. Now I need to make paper publication because as last known address, it was gone and served unclaimed. So unclaimed service may not be a good service. That's why, Lordship.
Special citation and publication of the copy of the same in one English daily and one Bengali daily. Mr. So-and-so, learned advocate for the petitioner, submits that by order dated 5th October 2023, special citation was issued to the years and years of the in compliance to order dated 5th October 2023, special citation was issued to the cited parties number 1 to 3, namely Natasha Chatterjee, Ria Chatterjee, and Robin Chatterjee. From the office of Deputy Sheriff of Calcutta. As per the report of Deputy Sheriff, Calcutta, the undelivered packets sent to the cited parties have returned with postal remarks, inverted commas, unclaimed. For such reason, the petitioner has filed the present application for issuance of special citation and publication of the same in the English and Bengali daily. He seeks in terms of prayer A of the master summons. Pursuant to order dated 5th October 2023, special citation was issued to the cited parties number 1 to 3. Act 1 to 3. As per a report of the Deputy Sheriff, Calcutta, dated 9th January 2024, the envelope has returned with postal remarks unclaimed. Considering the aforesaid and the amendments made in the application, as well as the submissions advanced on behalf of the petitioner, let there be an order in terms of prayer A of the master summons.
Grateful, my lord.
The draft copy is to be submitted before the department.
Yes, Lordship, Testamentary department will itself prepare the draft copy, and it will take at least 10 days time after service of this order, and thereafter I can publish.
Okay.
So I need 4 weeks time in total.
Let list this matter after 4 weeks. The GA1 of 2024 stands disposed of. 4 আচ্ছা এমনি আসবে ঠিক আছে GA disposed of. Okay.
Grateful, my lord.
Yes.
Much obliged.
Item number 15.
This is my application for reissuance of the citation, my lord, special citation, my lord, by an order dated 24th of August 2023, my lord. Special citation was issued.
Just a minute, sir. Just a minute. Yes.
My lord, by an order dated 24th of August 2023, my lord, special citation was issued in favor of 2 of the legal heirs of the deceased, my lord. My lord, pursuant to that order, special citation was issued, but one of the special citation was returned back to the special deputy sheriff, my lord, with an endorsement, my lord, left. That is, my lord, the cited party number 2, Srimati Kanon Kundu, my lord. My lord will get the report in page number 27 of my application, my lord.
Yes.
Thereafter, my lord, we have
one
made.
Has been served.
My lord?
One?
Yes, one has been served, my lord. If my lord sees page number 27, in response of this office has received on the 7th day of October 23, one undelivered packet with a postal remark left in respect of the cited party number 2, namely Srimati Kanon Kundu, and neither postal acknowledgement received nor undelivered packet in respect of the cited party number 1, my lord. My lord, there are moved from the cited address, my lord, to a new address, my lord. My lord, Kanon Kundu is the applicant's sister, my lord. And my lord will file the new address in page number 15, my lord, of my application.
But what about Kullani?
Kullani has received it.
No?
Yes, my lord. and neither postal acknowledgement receipt nor undelivered packet in respect of the cited party number 1, namely Kollani Paul, through General Post of Office. So the department has not received anything with regard to the cited party number 1, my lord.
Acknowledgement has also not returned.
Yes, my lord.
Then how it is served?
My lord, I am being instructed that it has received in the due course. And my lord will get the new address of the cited party number 2 in page number 15, my lord. That is, my lord, flat number 667, action area 2B, Bishiopathic, pin code number 700161.
Page 15.
Yes, my lord. Of my application, my lord.
Badalia Road.
No, my lord. Last, my lord. Flat number 667, action area 2B, Bishiopathic, pin code number 700161, my lord.
667.
Yes, my lord.
This you intend to incorporate in the?
My lord, original probate application, my lord. So I'm humbly praying for prayer A to D, my lord, of the master summons, my lord.
This is an application for amendment of the probate application. For incorporating the address of fourth daughter of the deceased, namely Kanon Kundu. Mr. So and so, learned advocate for the petitioner, submits that by order dated 24th August 2023, special citation was issued to Timothy Kanon Kundu. However, the undelivered packet has returned with postal remark left. For such reason, the petitioner has filed this application for incorporating the present address of Srimati Kanon Kundu.
And my lord, reissuance of the special citation.
And also for reissuance of the special citation.
The new address.
Huh? To be served upon Srimati Kanon Kundu at her changed address. He prays in terms of prayer A to
D, my lord.
D of the master summons. The অঞ্জন বাবু আছে? অঞ্জন বাবু যে অর্ডার্স গুলো আমি করছি না, এটা কেস পেপারস গুলো দিয়ে একটু পাঠাবে। By order dated 24th August 2023, special citation was directed to be issued to the cited persons. As per the report of Deputy Sheriff Calcutta dated 16th October 2023, the special citation issued to Srimati Kanun Kundu has returned with postal remark left. It is contended in the application that there is change in address of Kanun Kundu. Considering the aforesaid and the submissions advanced on behalf of the petitioner, let there be an order in terms of prayer A to C of the master summons.
A to D, my lord.
It would have heard you. Please wait.
Sorry, one.
Department is directed to carry out amendment to the probate application within a period of 3 weeks from date of communication of the order. There shall also be order in terms of prayer D for issuance of special citation be served upon Srimati Kanun Kundu at her changed address. Full stop. The application being GA1 of 2024 stands disposed of. আচ্ছা এটা তো ডেট পড়বে না
Grateful to your lordship.
Item number 16. Lordship, I am appearing for the petitioner. This is an application for amendment in the affidavit of assets and the petition for grant of probate, your lordship. Lordship, while filing the affidavit of assets and the petition for grant of probate, the petitioners had erroneously and inadvertently failed to include an asset of the deceased, your lordship, being Life Insurance Corporation of India pension policy.
Where is that?
Uh,
Which paragraph you have stated?
Lordship, page 2, point number 2, Lordship.
Petitioner filed the affidavit.
And Lordship, the necessary amendment that has to be carried out in the petition is at page 9, your Lordship. Page 9, point number 9, your Lordship. The amount will get changed after inclusion of the asset. And
This is the only amendment.
Lordship,
This is the only one.
and Lordship, at page 20 in the affidavit of assets, your Lordship, 20 and 22. Lordship, page 20, point number 4, the amount will change. And your Lordship, at page 22, the policy will be included in the asset, your Lordship.
Okay. This is an application for amendment of the affidavit of assets and the application for grant of profit. This and so learned advocate for the petitioner submits that the petitioners have erroneously failed to include an asset being the Life Insurance Corporation of India, Jivan Akshay, within bracket with final bonus bracket close pension along with other assets which needs to be incorporated by way of amendment in the probate application as well as in the affidavit of assets. आगे करो तुम्हें ना affidavit of assets टा आ गया. Considering the submissions advanced on behalf of the petitioners and the amendments made in the application, let there be an order in terms of prayer A to D of the master's summons. Department is directed to carry out the amendment within a period of 4 weeks from date of this order. GA1 of 2024 stands disposed of.
Grateful, Your Lordship. At number 17.
My lord, in this matter, I appear for the executor, my lord. My lord, this is my application, my lord, seeking acceptance of an affidavit filed by a legal heir, my lord, signifying her consent to the grant of the probate, my lord. What has happened, my lord, I tell your lordship, when the probate application was filed, all the legal heirs had filed their respective consent affidavits. Thereafter, my lord, scrutiny was done by the department, my lord. Certain errors were pointed out in the cost title, my lord, for which I had to take an amendment application. My lord, may kindly takes up page 56, my lord. The order allowing my amendment application is at page 56, my lord. 19 December 2023. I want to show, my lord, page 57, my lord, the second paragraph in there. I'm placing it, lordship. The attesting witness, stroke witnesses, and the heiresses in the intestacy who have affirmed affidavits in the old cost title are given liberty to file a fresh affidavits with the amended cost title within 1 month from the date of re-verification, reaffirmation as stated above. The department shall accept the affidavit of the attesting witness, and the consent affidavit with the amended cost title if filed within time and considered same for scrutinizing the application being PLA 587. my lord.
Witnesses and the considerably amended with amended cost title. Yes.
Now, my lord, after this, my lord, all the legal heirs, my lord, and the attesting we have filed in the amended cost title 7 except one legal heir, my lord, that is Supriya Sharda, my lord, who is the daughter of the testator, my lord, with his first wife, my lord. Now, my lord, I am praying that the earlier affidavit of consent which has been filed in the former cost title be accepted, my lord. I have not been, reason I have not been able to file is, my lord, that she stays in Bangalore, my lord. I have not been able to contact her post, my lord, this affidavit was filed, the application was filed, my lord. She is the daughter of the first wife, my lord. Relation, we do not, my client does not have any relation with her, and she lives in Bangalore, but he doesn't have any contact number, my lord. I have stated in paragraph, my lord, 9, my lord, at page 5, my lord, the reason why I have not been able to contact her.
So you could not file those her consent within the time specified in the order?
No, I have filed all the consents, 7 except 1, my lord. That is, kindly takes a page, page, my lord, 5, my lord, paragraph 9, my lord. Or, my lord, page 4, paragraph 8, my lord. Only one attesting, only one, my lord, contesting, contesting heir, my lord. Only one affidavit has not been filed, my lord, because she stays in Bangalore, my lord. I could not get her to affirm the affidavit for the second time, my lord. Now, my lord, with the original application, I have already filed my consent affidavit, my lord, which is I have annexed here at annexure C, my lord, which is at page, my lord, 59 of this application.
This was the previous one.
Yes, my lord. Which one?
It was the first one.
Yes, my lord, with the first wife, my lord, the daughter. The first one, yes, my lord. This was the first one. This is the first one. This is there in the record, my lord. May time kindly takes my master summons, my lord. If prayer A can be given, my lord, that this can be accepted. In the event, my lord feels that this cannot be accepted, my lord, I am praying for pair B and C. That is fresh issuance of special citation and general citation. Because the order directed me to file afresh in the amended cost title. I have not been able to do that, my lord. I have also not been able to, my lord, contact with the legal aid to file a fresh affidavit. So, my lord, A, my lord, I will be very grateful, my lord. If not, my lord, then B and C.
A cannot be allowed.
Same with
B and
B
C,
and C.
yes,
Kind of, yes.
because thereafter the order has been
Yes,
passed.
they have been passed.
GA 2 of 2020. This is an application for accepting the affidavit of Srimati Supriya Sharda, performed on 19th November 2022, signifying her consent towards grant of probate in favor of the executor, and in the alternative for issuance of special citation and general citation. Mr. So-and-so, learned advocate for the petitioner, submits that previously Srimati Supriya Sharda on 19th November 2022 affirmed affidavit signifying her consent towards grant of probate in favor of the executor. An application for amendment of the application for grant of probate was filed by the petitioners. By order dated 19th December 2022, the application for amendment was disposed of. With the following direction, এটাকে কোট করে দেবেন এই প্যারাগ্রাফটা 50 পেজ 57 এ দাগ দিয়ে দিলাম। He seeks for acceptance of the previous affidavit affirmed by Srimati Supriya Sharda on 19th November 2022, or in the alternative for issuance of special citation and general citation. By order dated 19th December 2023, this court directed the department to accept the affidavit of the attesting witness / witnesses and the consent affidavit with the amended cause title if filed within the time Therefore, Srimati Supriya Sharda was also to file her consent affidavit along with other years pursuant to order dated 19th December 2023. Admittedly, the consent affidavit has not yet been filed, as has been informed by the learned advocate. In view of the above, the prior A of master summons cannot be considered and stands dismissed or rejected. However, in view of the aforesaid circumstances, let there be an order in terms of prayer B for issuance of special citation on Srimati Supriya Sarda. Of this address is number.
This is correct, Milord. This
of number 1453, comma, 2nd Main Road, Banaksh Khan, 2nd stage, Bangalore. The address to dekhe neন. And issuance of general citation. GA2 of 2024 accordingly stands disposed of. পেপারটা দিয়ে দেবে না?
Item number 18.
It's my application in a testamentary proceeding manner. The executor, the sole surviving, has expired. The death certificate is page 12. It expired on the 5th of April this year. So on the death of the executor, my lord, the testamentary proceeding is converted to a letters of administration. Due to the applicants before lordship are the sons, 2 sons of the deceased, as well as beneficiaries under the will. It is a contested proceeding converted to testamentary proceeding, a testamentary suit. And examination and cross-examination of one of the attesting witness. Also, the executor has been done. So these procedural things, my lord, lordship will kindly come to page 12, which is the death certificate, the death of the executor.
Okay.
On the 5th of April 2024. The advocate was the executor himself. He was the executor to the will. Now, so I pray before lordship in the summons. Lordship will see the master summons. In the master summons, the death be recorded and is the prayer C, the consequential amendments which has to be done and will be converted to a application for grant of letters of administration with the will annexed.
Who is Chandra Kumar Kanoria and Lalit Kanoria?
Yeah, these are the beneficial son of the deceased, the Guljari Lal Kanoria. Today's applicant before your lordship is Chandra Kumar Kanoria and Lalit Kumar Kanoria. And been opposed by other son and daughter.
Effect will again the letters after conversion, the evidence in respect of this will be taken up.
Yes, others will have to lead evidence. So far, the
evidence as on record that will remain.
That will remain. Chief cross is over. That will remain. Other evidence will have to do it. We'll have to. Even I think
has been examined.
Examined, that has been done before, because the lordship will see the witness was old. So we had to do it in a deben essay before the judge's brief and other documents were disclosed. So only that portion has been done. After this amendment is carried out, it's been converted, we have to do all the formalities thereafter. We have to do it. I think the document disclosure and everything will follow.
The issue, my lord, that prayer B, my lord, as it stands, my lord, may not be granted the way it is constructed.
The English is wrong. The prayer B
is misleading. Otherwise, A, C, and B, whatever lordship.
No, that law elevator. The English is wrong.
Defendant number 3 and 4, my lordship.
I appear for defendant number 3 and 4 with the leave of your lordship. May I just say, Mr. Lordship, I can just plead with your lordship to just record that the question of locus with respect to the petitioners herein be kept open at the proceedings, because over here in the context of the will at question, whether the petitioners or the defendants herein be happen to be universal or residuary legatees, that question needs to be kept open, because that is directly constrained on the right of the petitioners herein to
always
to seek grant of the legacy. So that question may be kept open. That's all.
That is always, the issues have not yet been framed.
Of course, your lordship.
So that's the
Maybe kindly recorded, subject to your lordships.
হ্যাঁ ও চাইছে কিছু তো বলতে হবে দাদা আচ্ছা কি বল না নো ইস্যু
আসুন what he was indicating regarding prayer B?
Prayer B, when it is recorded that the application for grant of probate, now it is being treated. So I think there's a yes, lordship will English
will be converted to
yes, it will convert. is that the English is the grammatical mistake. Not the grammar, it's the construction mistake.
GA 5. This is an application for recording death of the sole executor, plaintiff, namely Ratan Lal Gaggar, alias R.L. Gaggar, and also for conversion of the application for grant of probate to one for grant of letters of administration. Mr. Aniruddha Mitro, learned advocate for the petitioner, submits that during the pendency of the probate proceedings, the executor, namely Ratan Lal Gaggar, expired on 5th April 2024. The petitioners
The legal heirs.
Being the legal heirs of the deceased are okay, petitioner.
Paragraph 1, Muller has said.
Legal heirs of the deceased being the legatees have the right to grant of letters of administration. He seeks prayers in terms of prayer A to D of the master summons. Mr. You are defendant? Defendant number 1 and 2 does not raise any objection.
And for the
Mr.
defendant numbers 3 and 4.
Defendant Mr. So-and-so, advocate for defendant number 3 and 4. Submits that
the objection was to the prayer B, the way
opposes the prayer B. Or again, John. Opposes prayer B so far as the construction of the prayer is concerned.
That's very constructive. That's your.
Prayer B is concerned. Mr. So-and-so, learned advocate for defendant number 3 and 4, submits that the right of the petitioner for grant of letters of administration be kept open and to be decided at the final disposal of the letters of administration. Upon going through the applications as well as the death certificate annexed to the application, it is found that the executor, namely Ratan Lal Gaggar, has expired on 5th April 2024. It is contended that the petitioners are the sons of the deceased late Guljari Lal Kanoria. In view of the above, let there be an order in terms of prayer A, B for conversion.
A, C, and D is perfectly doing what the petitioners are asking.
And Lordship can pass orders that be converted to, because even if you don't go by the language of
A,
The probate be converted to
Let there be an order for conversion of
Yes,
an
yes.
application for
Obliged.
grant of probate to one for grant of letters of administration with will annexed.
My lord.
Let also there be an order in terms of prayer C and D of the master summons.
Deeply obliged. Agreed.
GA 5 of 2024 stands disposed of.
বলে দিই তোমার প্রেয়ারে আছে আপনার তো প্রেয়ারেই আছে to carry out it to verify be treated as a
আচ্ছা ওইটা একটা নোট করে দিন, the right of petitioners for grant of letters of administration is kept open and shall be decided final decision. That is
Now, should we give a time period for carrying out the amendment? There is no timeline.
okay, department directed to
4
carry out
weeks.
the application within a period of 4 weeks.
Deeply
এই
Obliged.
draft টা যেটা সাবমিশন করেছিল will be
Obliged.
decided final disposal of the application.
Suit.
ওটা ওর সাবমিশন ছিল, আমি নিচে বলে দিলাম। Yes,
Obliged.
that will be decided what he has submitted.
Yes, yes, that's an order.
They are
That's-
right or not, that will
There
be
must be an order to the effect. That is submission. 4 हफ्ता
4 weeks.
4 weeks.
चलो
Obliged.
okay.
যাও। That next matter.
13 হয়ে গেছে, পারবে? Come back.
19 is just an application for discovery and inspection. Last occasion, not my other side is here. The last occasion,
এসে কিছু আছে নাকি দুটোর সময়? Continue.
there was a
Come
resolution
back, come
from.
back.
My lord will be sitting in the second. Yes, please.
কিছু আছে 3টের সময় কিছু স্পেশাল কি আছে? ও সেই ইয়ে আছে, ওই আছে অনিন্দ মিত্র আছে।
Daily causes item number 19.
My lord, this is my application for discovery and inspection. Under order 11, my lord, it's a application for grant of probate which was filed by the one of the daughter of the deceased. Then it was challenged by one of another daughter of the deceased. Now it has been converted to a testamentary suit. They have filed their affidavit in support of caveat, and now we have filed an application under order 11 for discovery and inspection upon serving a copy to them. Lord. And we have prayed for to direct both the parties to the suit to make discovery on oath of the documents which are or have been in their possession, power or custody, and provide inspection to either of the parties or the particulars of the documents relied by them within 10 days from passing order in this petition.
I am praying that 10 days may be extended for up to 4 weeks, subject to your lordship.
Why?
My lord, the documents are really scattered and my clients are also very low. It's, but I will not come again for praying for time.
Lord, first of all, we need to disclose our documents. Thereafter, we will furnish those documents to them. Relying on our documents, they will see that what are documents required by them to put it before this honorable court in order to challenge the proceeding. So if we can be allowed to disclose our documents within 2 weeks, we won't take more than that because our documents are ready. And we will give them the copies for their disclosures.
This is an application for
But I am pretty for 4 weeks then.
application for making discovery on oath of documents which are in possession, power, and custody, and for inspection of those documents by the parties, by either of the parties. So and so learned advocate for the petitioner submits that the suit has been, suit not, the probate proceedings has become contentious one upon filing of caveat and affidavit thereto. And as such, the discovery and inspection of the documents is required. He seeks for order in terms of prayer A of the master summons. Mr. So-and-so, learned advocate for caveator. You are for caveator?
Yes, ma'am.
Caveator submits that the time for discovery and inspection be preferably made within a period of 4 weeks. In view of these submissions advanced on behalf of the learned advocates and considering the amendments made in the application, let there be an order in terms of prayer A let such discovery on oath of the documents in possession, power, and custody of either of the parties and inspection be made within a period of 2 weeks. GA2 of 2024 stands disposed of within a period of 2 weeks.
Yes,
That can be, please, maybe 3 weeks at least, subject to your lordship's approval. Otherwise, I should not utter for 1 week.
Make it within 3 weeks. But find out that these 3 weeks has been granted. You complete your inspection and discovery, whatever. Don't again come and say that to extend the time and all. Yes.
Both the parties will complete the procedure within 3 weeks.
Yes.
Please, Your Lordship.
Either way.
Either of the parties, yes. Please, Your Lordship.
Item number 20.
Similar action, my lord. I am for the petitioner. Chief, I beg to appear on behalf of the defendant respondent. Application.
He also lodged a caveat and
This has been
subsequently converted into a contested judgment. I pray for discovery and inspection as in terms of my prayer of the master summons.
Prayer C.
One objection
No,
I
my lord.
have to his prayer A, that is not couched in proper form, your worship, because neither chapter 11 read with rule A of this honorable court's rule, read with order 11 of the CPC, order 11 rule 12 CPC, does not contemplate that he shall need a court's order on himself to disclose documents by filing a affidavit in relevant form. That he can do on himself only. Without carrying that exercise, he is coming before this court. He could have done that earlier and invited us
Since
to.
the application has been filed, let him do it. You also do it. Within a period of
That
6
is the
weeks.
principal objection which I have, your lordship. Prayer A to the
Yes.
application.
So and so learned advocate for the petitioner submits that. You are the caveator.
Yes.
Submits that upon filing of caveat and affidavit thereto, the probate application and be converted to has become a contentious one, for which the relevant documents needs to be discovered and inspected. Mr. Swenson, learned advocate for the caveator, submits that the application, the petitioner, plaintiff would have disclosed his documents as per
Order 11.
Order 11 of the Civil Procedure Code, which does not provide for seeking any order of the court for disclosure of documents. Considering the submissions advanced, same order C the master summons. Prayer C of the master summons. GA2 of 2024 stands disposed of. Huh? Right, 6 weeks for us. Discovery, inspection, documents between plaintiff and defendant be completed within 6 weeks. Bola ache C te. Order in terms of prayers. GA2 of 2024 stands disposed.
Great.
I'm grateful.
So great.
Item number 21.
Item number 21, I appear for the petitioner, my lord. That this is an application for substituted service of summons, my lord, under Order 5, Rule 20 of CPC.
চিংটা ঠিক করে নিয়ে আসো এই উপরে দেখে নি তাহলে
Yes, my lord. With regard to that left-hand side stitch, my lord, leave has been obtained from the court during the filing of the petition because it has been apostille document. This is a apostille document and it has came from United States of America, my lord. And that is where the stitch is on the right-hand side instead of left-hand side, and leave has been obtained by this court. The will and testament dated 18 December 2020. Testator died on 5th August 2022. Thereafter, my lord, citations were issued. My lord, the report, sheriff's report is at page 9, my lord. The legal heirs could not be served. Hence, I'm praying for prayers A to C of the master summons, my lord. My lord will find the mode of service at page 9, my lord.
One has left, another no person.
My lord's left, my lord. There are two addresses, my lord. On the second day of January 2024, one undelivered packet with postal remarks, no such person in respect of the cited party number 1, namely Olokananda Dotto at first address on Atho, one undelivered packet with postal remark left in respect of cited party number 1 at the second address. Now the second person is Omitabo Raha, wherein it has been remarked as door locked at the second address, and have a comment tracking report has no problem. And the first address, it could not be served, my lord. My lord will find the addresses of the respondents at page number 2 and 3 of my application, my lord.
In USA, it has been served.
Yes, my lord. Yes, my lord. That's why I have prayed for Strait Times in Sunday edition at Singapore, because the address of the first respondent is at Singapore, my lord, where Olokananda Dotto could not be served either in Singapore and also in Kolkata. And the second person could not be served in Kolkata. That's why, my lord, I prayed for এই সময় Times of India and a newspaper, Strait Times, which is Delhi in Singapore.
Only one. Only
Yes.
in respect of one.
No, my lord, 1 and 2, because my lord will find in page number 3 of my application, Omitabo Raha, he has two addresses. One is at USA and also residing at AC 161 Sector 1 Post Office Bidhannagar, Police Station Bidhannagar, North 24 Parganas. So, my lord, I have prayed for এই সময়, and one in Bengali Delhi, one in English Delhi, এই সময় in Bengali Delhi, Times of India English Delhi, and the respondent number 1 who could not be served in Singapore, my lord will find in page number 2, 1 Hume Avenue, Singapore. So I have prayed for publication in Strait Times in Sunday edition at Singapore. My lord, prayer A of my master summons.
The order was passed for issuance of special citation.
Yes, my lord.
Where is
An
the
order, an order was passed, my lord, by Justice Arindam Mukherjee.
Where is it?
My lord, my lord, presently I'm not having the order, my lord.
What is the date of the order?
My lord. October, 6th October. My lord, I'm 21st September 2023. General citation was issued and whereby it was directed to affix at the notice board of this court, notice board of the collectorate of North 24 Parganas, and another copy be affixed at a conspicuous place, being the immovable property bequeathed under the will.
21st September.
21st September 2023.
Order date.
21st September 2023. Passed by Justice Arindam Mukherjee.
Awesome. An application for publication of special citation for substituted service on one of the legal heirs of the deceased, namely Alokananda Datta, in one English newspaper, Bengali newspaper, and one English newspaper at Singapore. Mr. Dhilon Sengupta, learned advocate for the petitioner, submits that pursuant to order dated 21st September 2023, special citation was issued to the legal heirs of the deceased, namely Amitabh
Raha.
Alokananda Datta and Amitabh Raha. However, the undelivered packet has returned with postal remark. No such person / name, it inverted comma mধ্যে রাখবে, in respect of the first address. With regard to the second address, the undelivered packet has returned with postal remark left. He seeks for publication, issuance of special citation, and publication of the same in English, Bengali daily, and one English paper at Singapore, in terms of prayer A of the master summons. Special citation was issued, paragraph. Special citation was issued upon Alokananda Datta. Stop. Pursuant to the order dated 21st September 2023. The report of Deputy Sheriff Calcutta dated 4th January 2024 shows that the undelivered packet with postal remark no such person/name in respect of Alokananda Datta at the first address and with regard to the second address, the undelivered packet has returned with postal remark left. Accordingly, in view of the aforesaid, let there be an order in terms of prayer A of the master summons. A and B করে দিন। A and B of the master summons.
Well, the department be directed to prepare the content of the newspaper advertisement within a period of 2 weeks, my lord. Because I have prayed for returnable after 8 weeks from the date of publication.
Department is to take appropriate steps. Any.
Grateful, my lord.
It is non move.
Item number 22.
GO disposal.
Item number 22.
Lordship, in this matter, I am appearing on behalf of the caveator, Lordship. On last occasion, your Lordship has given a direction for filing affidavit in opposition and reply. Till date, they have not filed an opposition, Lordship. Now they have come with an applications for retirement of an executor, Lordship, and let this matter be appeared on 22nd July, Lordship, because our application is due to appear on 22nd of July, Lordship.
My lord, order booked in.
There is two executor, my lord. One will retire and another will be reinstated.
22 तारीख आज में अच्छा what is that
GA1A.
One.
Yes, Lordship.
GA1 is your application.
Yes, Lordship.
What is the prayer there?
Our prayer, Lordship, that not to create any third-party interest, Lordship. I am a sole beneficiary of the will, and let them give a copy of the original documents they have not filed, Lordship. That is why we have filed an applications. And if your Lordships kindly take out my master.
Who is the petitioner of the probate proceedings?
Yes, Lordship. They are the.
You are.
She is the now petitioner, my lord. He is the executor. There is two executor, my lord. Rajendra Sipani and Nobin Kotari. My lord, Rajendra Sipani has filed this application, my lord. Now he is want to retire from this.
Who is the applicant in the probate proceedings?
Rajendra Sipani, my lord.
Your client?
My lord, my client is the Nobin Kotari.
Your client is not the applicant of the probate.
My lord, I am the, there is two executor, my lord. Now, my lord,
Who is the applicant of the probate proceedings?
Rajendra Sipani, you. Oh. My lord, Rajendra Sipani has filed his no objection, my lord. And he file an application for his retirement, my lord. And I have filed an application, my lord, for reinstatement. In his place, my lord. There is two executor, my lord, who can act jointly and severally, my lord. But my application fixed on 22nd, my lord. Kindly fixed on 22nd, my lord. Before the master, my case, my application is fixed.
On last occasions, they appeared, Lordship, on behalf of the Rajendra Sipani, Lordship. The junior advocate was appearing, Lordship, all throughout.
No, I am not Orgodip.
No, only to Orgodip Das.
No. He is Roshan Sarda. He is my junior. I am Falguni Bandyopadhyay. Okay? Yes, now he has filed an application for his retirement.
Both the learned advocates for the respective parties submits for fixing the matter on 22nd July. Well, on the prayer, on the prayer of learned advocates for the respective parties, place this matter on 22nd July. Anyway, 22nd.
My lord.
Item number 23.
Hello, this is my application seeking a formal amendment, my lord, in the letters of administration petition, my lord, which has been allowed, my lord, under the circumstances, my lord, that while drawing the bond, my lord, an error was detected and, my lord, consequential reliefs are to be had. My lord, kindly see the prayers, my lord, the proposed amendments have been indicated. Prayer A, Lordship will find in annexures D and E. My lord, I'll
First, show me the order for grant of letters of administration.
Yes, my lord, kindly come to the order is at page 7, 12th April 2024.
Okay.
My lord, while drawing the bond, my lord, what had happened, my lord, this application was filed by the father who was acting as the power of attorney holder on behalf of the son, my lord, who was the applicant. Now, my lord, Lordship will kindly see, my lord, kindly come to annexure D. Lordship will get the nature of the amendment, page 18. But while furnishing the bond, my lord, it appeared that, my lord, the agent's name was mentioned first. The power of attorney holder's name was mentioned first in the petition and thereafter the principal. It has to be the reverse. So when that was, my lord, pointed out, my lord, consequential. Kindly see page 18, Lordship will get that. My lord, if Lordship ignores the reading portion, the original petition was humble petition of Shubhendu Rai, son of late Omulya Ratan Rai, so and so, being the constituted attorney of Amit Rai.
Okay.
So Amit Rai was the principal. It is now just the reverse. Amit Rai, son of Shubhendu Rai, so and so. And Millard, this is the exact amendment, Millard. The other amendments which have been sought, Lordship will find. Similarly, Millard, in the page 15 and 16, Lordship will find, Millard, the same category wherever it has been mentioned in reading. It is just the reverse, only because of reversal. Similarly, para 16 also at page 24. And, my lord, consequentially para 17. And therefore, my lord, the consequential amendments in prayers A and B. And, my lord, annexure E is the affidavit of assets which was affirmed by Shubhendu Rai. There also, my lord, para 1 that Lordship will find at page 31. Lordship will kindly consider the prayers, my lord. Prayers, my lord, A to E, Lordship will kindly grant it. These are all consequential. Re-verify, reaffirm the affidavit of assets, and, my lord, prayer E is to waive off the proposed amendment in affidavits of consent, because, my lord, these consents are from the two other heirs, one in Norway and one in USA. All that has come, my lord, that is why the formal. This is only, my lord, if it is
Earlier, they have given their consent.
already given the consent, it is there. This is only because of that. Otherwise, my lord, the bond, the fixed deposit is ready, my lord. It cannot be processed because, my lord, the order says this, the department has indicated it. It is only because of this. Absolutely formal. There is nothing. A to E if Lordship considers. And it's a non-contested. Paragraph 9 is the main paragraph, my lord, where we have stated the reason. Page 5, para 9.
This is an application for amendment of the application for grant of letters of administration as well as the affidavit of assets. Mr. So and so, learned advocate for the petitioner, submits that by order dated 12th April 2024, the grant of letters of administration was allowed, with a direction to the petitioner to furnish a personal bond for a sum of rupees 32 lakhs with one surety. At the time of execution of the bond, in compliance, it was inadvertently detected that the words Amit Roy by the pen of above the signature of the constituted attorney, namely Shubhendru Roy, alias Dr. Shubhendru Roy, and the words constituted attorney below the said signature were not subscribed. For such reason, the applicant has sought for amendment in terms of prayer A to E of the master summons.
Prayer to pay actually.
Considering the submissions advanced on behalf of the petitioner and the averments made in the application, let there be an order in terms of prayer A to E of the master summons. GA 1 of 2024 stands disposed of. Record a particular.
Deeply obliged.
Is there any time period given in your application for carrying out this amendment?
Yes, my lord, we have stated that in prayer B, if lordship sees, my lord,
3 weeks.
3
Okay,
weeks. my lord.
department is directed to carry out the amendment within a period of 3 weeks.
Deeply obliged.
Item number 24.
And this is my application. On the last occasion, my lord, your lordship had directed to my lord, inform my lord, the special officer. But I'll tell you, lordship, my lord, briefly, my lord, what the matter is about. My lord, this is in respect of my lord, property in Howrah, where my lord, initially, my lord, a suit was filed for recovery of rent of the warehouse, the property in Howrah. And my lord, that suit was decreed, my lord, in a application for summary judgment. Thereafter, another suit was filed before the Howrah Court for recovery of possession. Now, my lord, both the suits were compromised by a terms of settlement, and my lord, the parties had my lord, appointed a special officer to my lord, take my lord, whatever my lord, goods were lying of my lord, the defendants in the godown, to take those goods away and sell it and recover whatever money is due and payable to the plaintiff. Now, after that, that suit, the terms of settlement, the compromise decree was passed, and now, my lord, we are before your lordship. The receiver has intimated and informed that he is unable to continue because of his illness. That I had indicated on the last occasion, and lordship's desire was to, my lord, serve it on the special officer once, as well as the parties. So I have
Special
also
officer
informed
means
the
a
parties.
receiver. Receiver is the special officer.
Special officer. Special officer. I've also filed my affidavit of service. Lord, today, my lord, I'm humbly beseeching your lordship, if your lordship
Yes, yes.
I'm humbly beseeching you, if your lordship kindly appoints any my lord, other person my lord, in place and stead of the learned receiver, and my lord, let my lord, the terms be implemented my lord, to the extent that the goods may be my lord, recovered from the godown, and my lord, a sale notice may be issued by the special officer and take appropriate steps to sell it so that the dues of the
is
decree
the-
holder can be recovered.
Where is the order of appointment of special officer and the duties that were given to the special officer to
No,
carry out?
that is what exactly I was on. If your lordship kindly sees the terms of settlement, the terms of settlement starts at your lordship page 20. Your lordship will find at page 21, clause B, Mr. Shuchoyan Chaudhary, advocate of 5 Kiran Shankar Roy Road, is appointed as the special officer for giving effect to these terms of settlement between the parties in the instant suit. The special officer shall be provided with all logistical and secretarial support for the purpose of executing these terms of settlement by the parties herein. The special officer shall allow the defendant numbers 2 and 3 jointly to take out the lots, that's the goods which are there in the go down, subject to a maximum of 5 lots. All the machinery, stocks, raw materials, accessories, etc., as are lying inside the warehouse, as is various basis, in the presence of the authorized representative of the parties. Taking out of the first lot shall be allowed to the special officer only upon receipt of the first payment. The first payment was received after the due date, which is specified over here. Hence the default clause, and hence the entire amount was due and payable. That clause your lordship will find in the next page, internal page 4 of the terms of settlement, clause I. In case of default of the defendants in making the payment of the agreed sum of rupees 15 lakhs or any part thereof within 28th of March 2021, in the manner as stated above, the amount decreed being a sum of rupees 26 lakhs. And odd rest shall be paid, if not already paid, by the defendants to the plaintiff under this terms of settlement, along with interest of 12%. That is what we have claimed in this execution application. And pursuant to this, your lordship will find the decree, which is what has been referred by the learned special officer in its letter. Your lordship will find it at page 28, the drawn up decree. I took your lordship through the terms of settlement, the typed copy of it. The drawn up decree also contains the handwritten version of the terms of settlement, page 28.
Yes.
Now, if your lordship, what I'm humbly beseeching your lordship is that the receiver may be appointed in place and stead of Mr. Shuchoyan Chaudhary, who has expressed his unwillingness and really due to inability. The terms of settlement may be implemented to the effect which has now part of a compromise decree, so that the goods can be recovered from the warehouse and can be sold and the dues can be recovered.
You've given notice to the judgment debtor?
Yeah, I have also done that. On the last occasion, lordship had indicated, I have given a notice to the judgment debtors. That's part of the, I've filed a affidavit of service. And page 7, I believe, Murad, is the delivery report, the track report. Prayer A and prayer N of the tabular statement. In fact, Mr. Shuchoyan Chaudhary had done some amount of work, which is indicated in the minutes, but he couldn't take out the entire lot which is there in the godown. In fact, for that also the decree holder has incurred expenses, which is also part of the claim.
Any report has been filed by him?
I'm sorry, my lord.
Any report has been filed by Mr. Chaudhary?
No, my lord. Only the minutes I have annexed, my lord. Thereafter, because of his health, perhaps, my lord, this has, my lord, come to this situation. Page 40 onwards, your lordship will find the minutes of the meeting. In fact, from page 40 onwards, your lordship will also find that the first tranche of payment, which was to be paid by the judgment debtors, had been paid after the due date, which is why the default clause was activated.
Before this meeting, any sort of papers were handed over to Mr. Suchayan Chaudhary?
I'm sorry, my lord.
Any papers were handed over to Mr. Suchayan Chaudhary?
No, my lord. No papers.
This was the solitary that meeting has been held.
Not the solitary meeting. There were total, my lord, total 13 meetings which were held from 20th of March 2021 to 24th of December 2021. I have annexed all the meetings, minutes of the meetings, starting from page 40 onwards. Your lordship will find in none of these meetings were there any exchange of documents. It was really the materials which had to be taken out from the go down. The last minutes your lordship will find is at page 63. 63, my lord. Page 63. The go down was locked because it was during the COVID time and the materials could not be lifted on that day. Oh, I'm sorry. If your lordship kindly takes page 64, your lordship will find the go down was unlocked. They unlocked the go down, lifted some of the materials, and thereafter the truck was brought. Truck number has been given. Lifting of materials continued till 5:30, and thereafter it was locked again. I'm sorry.
This godown is warehouse number 10.
Yes, that is a suit property. That is a suit.
The keys are lying with the special officer. C64, last two lines.
Yes, Manoj. Lock and the go down again kept locked and key were handed over to the special officer who left the site at his residence. So that your lordship can direct to get the keys from the erstwhile Malad special officer. I am grateful to lordship.
Yes, thank you. Asunto. Affidavit of service filed on behalf of the decree holder is taken on record. A copy of notice sent to the special officer, Mr. Where is that letter of yours sending a letter to the special officer? Where is
It's
it?
part of the affidavit of service. My lord, if your lordship kindly takes page 4 of the affidavit of service.
Copy of letter issued by the special officer Suchoyan Chaudhary is also produced by the learned advocate for decree holder. Mr. Shankarshan Sarkar, learned advocate appearing for the decree holder, submits that the special officer has intimated that he is suffering from multiple myeloma and is bedridden. In such circumstances, he prays for prayer A for discharge of the special officer and appointing a new special officer to carry out the duties in terms of the terms of settlement of the decree. None appears on behalf of the judgment debtor. By the terms of settlement dated
22nd February 2021.
22nd February
2021.
21.
And the decree is dated 11th March.
No, you just indicate the page number you have just indicated.
Yes, page 20. Your lordship will find the terms of settlement.
No, the appointment, I guess.
Oh, the appointment, your lordship.
B, no?
At page 21B, yes.
Mr. Suchoyan Chaudhary was appointed as special officer for giving effect to the terms and settlements between the parties in the instant suit. It manifests from the letter of the special officer dated 8 July 2024 that he is bedridden, having detected from multiple myeloma. In view of the above, the special officer Mr. Suchoyan Chaudhary is discharged. Mr. Shaunak Mukhopadhyay kore? Can I act? Mr. Shaunak Mukhopadhyay? কোনো আছে কি মিস্টার সৌনক মুখোপাধ্যায়? হ্যাঁ, মিস্টার সৌনক মুখোপাধ্যায় উনি কোন বারে আছেন?
Bar Library Club.
Bar Library
Club, second floor.
Bar Library Club. Member of Bar Library Club is appointed as special officer. He's there.
But he was just here. He was just sitting.
To be appointed as special officer to discharge functions in terms of the terms of settlement dated
22nd February 2021.
Let there be an order in terms of prayer A of the tabular statement. Special officer is directed to submit report.
Lordship will also pass an order in terms of prayer N, because A is only discharge. And N is appointment and the subsequent acts that the special officer needs to do.
Prayer
N.
A and prayer N. N of the tabular statement. ওই যেটা বললাম A এবং N, হ্যাঁ, special officer shall submit report on the returnable date. Let the matter. There is an order of injunction. You're enjoying.
Yes, my lord. Your lordship had injuncted, my lord. Let that my lord also continue, my lord.
Release this matter after 4 weeks. Let the report come from the special officer. Any.
My lord, only two things, my lord. One is, my lord, in lieu of my lord, the special officer, the remuneration may be fixed of the special officer, my lord. And my lord,
what was the other person? Is there any order?
My lord, there was no order to that effect, my lord. Your lordship, my lord, whatever your lordship desires, my lord, because the special officer has to go and my lord, take out my lord, the goods from
30,000, 2,000, 2,000 gems.
Very good. And my lord, only one thing is, my lord, your lordship has directed my lord prayer N. My lord, in that, my lord, your lordship had my lord. Oh yes, it contains everything. My lord, it contains everything. Oh, would it be your lordship's pleasure to also indicate that the erstwhile special officer may assist and cooperate in whatever he has.
Now, since he has been discharged, I direct him to hand over all the necessary documents as well as key of the warehouse.
I'm so grateful. Please,
Mr. Suchan Chaudhary, the erstwhile special officer, is directed to hand over the papers and the key of the godown to Mr. Mukhopadhyay, the new appointed special officer. Right.
I'm grateful.
Sure. না 3টে বেজে গেছে, ক্রস করবে তো? পার্টিজ আছে, আগে দেখে নিন পার্টিজ আছে কিনা, তাহলে নিয়ে নেবো। আদারওয়াইজ একবার ডেকে দিন ওটা, উইটনেস অ্যাকশন।
লাগবে আমারটা 2 minutes. My lord, the attesting witness is here, my lord, to prove the will, my lord. To probate. My lord, this is for grant of the probate, my lord, of the will dated 30th September 1997 of Madhav Das, Srimati Madhav Das Bonik, my lord, who died on 9th May 2005. Madhav Dasi Bonik, who died on 3rd May 2003, my lord. My lord, the attesting witness to the will.
আমাকে যেগুলো বড় অর্ডার হবে, caveat was filed.
My lord,
I am the advocate on record in this matter. May I tell your lordship, my lord, that one of the class 2 heir did not give consent at the time of filing. So, my lord, this honorable court was pleased to issue the special citation. Special citation was served, and the class 2 heir, Arun Kumar Bonik, he appeared, filed the caveat through his advocate on record, and
thereafter filed the affidavit in support of caveat. Thereafter, my lord, your lordship knows that as per the procedure, the probate application was converted to the testamentary suit, where Arun Kumar Ghosh's affidavit in support of caveat was treated as the written statement and the testamentary suit number was allotted. Now, my lord, that testamentary suit is now coming before your lordship for examination of the one of the attesting witness. Now, my lord, the defendant, I tried to serve the notice, prior notice upon the defendant's advocate on record, Arun Kumar Bonik's advocate on record, Miss Srimati Sucheta Bormon. She was the advocate on record of Arun Kumar Bonik. My lord, she refused to accept the notice. My notice, she refused to accept on the ground that client has taken change of advocate from her. She is not acting as her advocate on record. So I, my lord, getting no other alternative, also tried to serve the notice upon Arun Kumar Bonik at his address. There also, my lord, the notice was refused and come back. My lord, virtually this matter is now appearing as unopposed application, as an undefended testamentary suit. Now, my lord, only one witness is here, attesting witness. My lord, on my prayer, your lordship was pleased to fix the matter today for examination of the attesting witness.
You noticed, you have served the notice upon the learned advocate, erstwhile learned advocate for
lordship,
the caveator.
Arun Kumar এখানে নেই, আমার কাছে আছে। ব্রিফ গুলো দাও, ব্রিফটা দাও। একটু জজ সাহেবকে দিন, উপরে এডিটা লাগানো আছে।
When was this caveat filed by Arun Kumar Bonik?
Arun Kumar Bonik filed the caveat. Also, my lord, the affidavit in support of caveat also filed on 20th of July, my lord, 2020.
20.
20.
There were other also caveators?
My lord, there were other two caveators, but ultimately they did not file any affidavit in support of caveat,
Okay.
and their caveat was also subsequently discharged. 2020 October.
You have filed this affidavit of service.
But
এটা দেখুন তো, এটা 16th এ বলছে, 16th মে তে আফার্ম হয়েছে, অ্যাফিডেভিটটা ফাইল করেছে।
আমাকে দিক 16th May 2023, my lord, the affidavit of service is filed. My lord, that is GA4 of 2023. GA4 2023.
Photo. কিসের application?
Well, this was an application for discovery. After filing written statement, step was taken on behalf of the plaintiff for discovery of documents.
Or has been disposed of?
No, that application is pending. Still it is pending. Because
that
yes, defendant himself has received the notice but did not appear. His advocate on record has also not appeared. My lord, may I suggest to your lordship, my lord, if it is comments to your lordship. My lord, advocate on record for the defendant is Sucheta Bormon. Nobody has claimed any other advocate that they are appearing on behalf of the defendant. So our power is still lying in the record. My lord, if your lordship so direct me, I can give a notice that it is your lordship's pleasure to come before your lordship.
Submit that some other advocate has appeared on behalf of Arun Bonik.
Nobody. I have ascertained from the department, no other advocate on record has appeared in the place and state of Sucheta Bormon. Probably it may be possible that her client is not contacting her. That's why she is not coming or taking any responsibility to receive anything. But that should be explicitly clear that either she has to take the retirement, my lord, or she should appear. My lord,
okay. You give a notice to her. I get a report from the registrar insolvency.
Communicate in that notice that it is your lordship's pleasure to be present before his lordship on particular day and time. Otherwise, she will not accept the notice. If your lordship gives me the liberty, my lord, I can communicate it to her that your presence is necessary.
Ashun. Mr. Sobhusachi Sen, learned advocate appearing for the petitioner, submits that the erstwhile learned advocate for the petitioner, the learned advocate on record for the defendant refused to accept the notice for causing inspection of documents, discovery and inspection of documents. He seeks to serve another notice upon learned advocate or the advocate on record for the defendant. Learned advocate for the plaintiff is directed to serve notice upon Srimati Suchita Sharma, advocate on record for the defendant, intimating the next date of hearing and to remain present. Is this matter? 26th July 2024 at 3 p.m. কোর্টটাকে তো আনিয়ে নিলে হয়, পুরোতে একটা অ্যাফিডেভিট আছে। আচ্ছা, এটা কি রেকর্ডেড হয়নি GA1? আচ্ছা, এই অর্ডারে ডিসপোজ হয়েছে by order dated 9 January 2020
26 না করে 25th করে।
এই এটা কি করে আসছে লিস্টে অঞ্জন বাবু? ওর তো অর্ডার দিয়েছেন ডিসপোজড অফ। Register IT. Register IT is directed to record GA1 of 2019 as disposed of. 26 July. চল। এটা দিয়ে দিন। 1st August, ঠিক আছে 1st August দেখে নিন এটা 1st August 3 PM 1st August.
Already, Your Lordship, this order I am communicating to Suchita Bharti.
Suchita Burman, yes.
Item number 25.
Lord, item number 25 is my execution application, my lord. This is execution of an order of, my lord, July 2012, my lord. So, my lord, 2 years have passed, my lord. I was only praying, my lord, if a notice may be issued, my lord, to the judgment debtors, to, my lord, for effecting service, and, my lord, they may be directed to appear, my lord, in terms of Order 21, Rule 22. And, my lord, I also have another innocuous prayer, my lord. If your lordship sees, my lord, my tabular statement, my lord, my affidavit, my lord, if your lordship sees a tabular statement in column 7, my lord, I have inadvertently, my lord, in the column, my lord, the amount of debt or compensation with interest, if any, upon the decree or order or other relief granted thereof, my lord, it says, my lord, nil, my lord. However, I've, my lord, prayed for, my lord, an amount of rupees 60 lakhs, which is due and payable by the judgment debtor to the decree holder, my lord. My lord, I've given them an adjustment of 10 lakhs rupees, my lord, which is appearing at column 5, my lord. The balance is, my lord, indicated, which is at 60 lakhs. Lord, I ought to have put that in column 7, my lord. I haven't done that, my lord. I was only praying, my lord, if lordship may grant me that liberty, my lord, to make that correction in column 7, my lord, and serve upon them the amended copy of the execution application, my lord. My lord, at page 5, paragraph 17, my lord, I have stated the particulars of the amount due and payable by the judgment debtor to me, my lord.
CPC টা দিন। CPC
Or Order 21, Rule 17, my lord.
Order 21 Rule 17.
Yes, my lord. Order 21, Rule 17, my lord.
আসুন আসুন Mr. Ansel, learned advocate for the decree holder submits that as per the decree, the total amount payable to the decree holder by the judgment debtor is rupees 60 lakhs. Which has been stated in para 17 of the application. However, in the tabular statement at column number 7, the said amount has not been stated. He prays for necessary leave to correct the application for execution of decree under Order 21, Rule 11. Upon going through column 5 of the application for execution of decree, it is found that the balance amount payable to the decree holder as stated therein is rupees 60 lakhs. However, column 7, the amount of debt or compensation due upon the decree has been mentioned as nil. The application at paragraph 17 also states of the balance outstanding amount as rupees 60 lakhs. In view of Order 21, Rule 17, leave is granted to the decree holder to make necessary correction in the application for execution in the tabular statement. In the tabular statement of application for execution of decree in column 7, as aforesaid. Ms. Suen So, learned advocate for decree holder, seeks for issuance of notice to the judgment debtor. Let notice is issued to the judgment debtor after 4 weeks. Release this matter after 4 weeks. You make your necessary correction within 2 weeks. Time to within 2 weeks. Shall carry out necessary correction within a period of 2 weeks. Release this matter after 4 weeks. Okay, কি বললাম? Department is directed to issue notice of the amended execution proceedings. Application, proceedings and application. Anyhow.
Grateful.
I don't know, 26.
Lordship, this is my application for execution of a decree which emanates from a judgment dated 24th August 2023. It is within the period of 2 years. Your Lordship, it was an ex parte decree passed by Honorable Justice Arindam Mukherjee to the tune of 67 lakh 17 16,808 rupees. Your Lordship, the plaintiff has the decree, the debtor has not been appearing ever since. We've attempted to serve notice also. If I may just kindly invite your Lordship's kind attention to internal page number 4, paragraph 8. Your Lordship, that is a description of the yes. Internal page number 4, paragraph 8. Your Lordship.
Yes.
Your Lordship, this is the one immovable property that is within our knowledge with respect to the judgment debtor. On the subsequent page, if I may draw your Lordship's kind attention, page number 5, that is the bank account of the judgment debtor. If I may, if your Lordship is with me. Yes. Lordship, if I may pray for your Lordship's kind indulgence in allowing me to secure this amount and thereby granting an order of restraint upon the judgment debtor to operate this particular bank account and the immovable property to the tune of 67,17,808. And in that regard, your Lordship, in the interest of fairness, I must point out, your Lordship, column 10 of my tabular statement, there is an inadvertent error. However, that is not fatal to my application. It says, and if I may assist, a decree for a sum of so and so will be a payment for a sum of so and so of 67,17,808. It is within the period of 2 years, your Lordship. No appeal has been preferred. Section 47 application has also not been preferred by the judgment debtors. The
passed on which date?
24th of August 2023, your Lordship. Your Lordship will find a copy of the decree on page 12 of my application. It's annexure A. Your Lordship, it was an ex parte decree. The conduct of the defendant, the judgment debtors is vociferous that there is no element of congruity in this. My lord, subject to your lordship's very kind consideration, the conduct of the judgment debtor throughout the proceedings, it does not evoke any confidence. The amount will merely reflect on paper as a paper decree if my interests are not secured. Is in light of that, if I may kindly pray before your lordships for securing this amount of 67,17,808.
আসুন আসুন Yes. Mr. Swen Sulaner, advocate for the decree holder, submits that the defendants despite service of notice did not appear in the suit. And the suit proceeded ex parte. On 24th August 2023, ex parte decree was passed, awarding a dictatorial amount of rupees 6717808. 17808. In order to secure the data of the decree holder, the bank account of the judgment debtor judgment debtor, there should be an order upon the judgment debtor not to operate its bank account, the details of which has been provided in para 9 of the application. An ex parte decree was passed on 24th August 2023 for an award of rupees 6717808. Considering thereafter, this execution case has been filed within a period of 2 years. In view of submissions advanced on behalf of the decree holder, the judgment debtor is restrained from operating the bank account নাম্বারটা প্যারা 9 এ থাকবে, প্যারাগ্রাফ 9 এ আছে ডিটেইলস, ঠিক আছে? For a period of 4 weeks, or 6 weeks করে দিন, সার্ভ করুন 4 weeks পরে রাখুন, for a period of 6 weeks or until further order, whichever is earlier. Learned advocate for decree holder is directed to serve notice upon the judgment debtor. Let the matter list this matter after 3 weeks.
Lordship, I apologize. I should have brought this up earlier, if there could kindly be a direction upon the judgment debtor to produce their affidavit of arrest once they enter appearance, should they enter appearance in that
We'll
case.
give notice. If they enter appearance on that day, direction will be passed.
Lordship, Lordship. Extremely grateful to you.
After 3 weeks, this will appear. এটা চলে গেল, লিস্টটা চলে গেল, একটু দিন না।
Adjourn motion item number 27.
My lord, my application, my lord.
But I am appearing for the trustees Shoibal, Narayan Deb and Taposh Mitra and Devraj Mitra, the advocate on record, Mr. Shovik Mitra is not keeping well on his.
On last occasion also, my lord, when the matter was called up by my lord directed me to serve the notice that the matter would appear. This is my affidavit of service.
On his behalf, I am praying for adjournment.
This cannot go on, my lord. This is a matter of 2022. The
Kindly
4
please serve
trustees
any
were
day on the
appointed
next
by
week,
this
my
court.
lord.
One of my, I am appearing on behalf of one of the trustees. The other 3 trustees, clubbing hands with each other, have sold the entire property. They're selling the properties of the Rajbari, Swabaja Rajbari, the trust properties, without seeking any permission from this court. This cannot go. And the order which was passed earlier that the term of the board of trustees should be for 3 years. The 3 years has already elapsed. Now they are in interim period. They are running the board and they are just siphoning off the funds, everything. My lord, this is my affidavit of service. It has been delivered on 18th. My lord, the matter was taken up by my lord, and since the board of advocate for the board of trustees did not appear, my lord had directed me to serve the notice. I have served the notice. It has been delivered upon him. He is intentionally not appearing in this matter, my lord. This cannot go on. This is the application of GA5 is 2022. If my lord takes up once the application, they are selling off, and in spite of my client, one of the trustees, giving notice that how are you selling these properties without seeking any permission from the court, they are selling it off. We don't know how it has come to our knowledge that 2 of the properties in Sodhpur has been sold off. The consideration money, if my lord takes up the deed once, I have annexed the deed. The valuation of the property was for 48 lakhs 52,000. If this money would come to the trust, that would be beneficial for the trust. They have sold that at rupees 5 lakhs, this property.
Who will appear?
And Mr. Shovik Mitra, he is led by senior advocate Surajit Nath Mitra. They appears in for this.
Last occasion, my lord, on the last few occasions, they did not appear.
No, my instruction is only that he is not keeping well for the last week, and he has asked me to kindly pray for adjournment for a week. This week, in any week, any day on the next week.
Monday.
Monday, yes, I will.
My lord, I do appear for one of the beneficiaries of this trust. As indicated by my learned friend, there's a complete mismanagement, my lord. Properties have been sold without permission of the court at a throwaway price. On a first, my lord, it's a well settled. It's a law says, my lord, before you sell a property of a trust property, you have to seek a permission. Here, your lordship will find no permission, nothing, my lord. Say by this trustees, court-appointed trustees have sold properties. Now, this is the first contention. My lord. Second, my lord, this appointment of the trustees were made for a limited period.
For a period of 3 years.
3 years. The order of Honorable Justice Chakraborty, as his lordship then was, has appointed. Now, that period has elapsed a long period of long back. Now, thereafter, orders were passed, my lord, for a temporary extensions, my lord, to run the trust estate, my lord. Now, what has happened, my lord? I have taken out an application, my lord, giving a detail of what has happened, my lord. That's IAGA number 10 of 2024, my lord. That was supposed to appear before, my lord, on the 12th, my lord. It has not appearing today, my lord. Let that appear on the Monday, my lord, in the morning, my lord, at the motion stage, my lord. And I will be seeking for an interim relief in that application because this trustees, the 4 trustees, according to me, cannot run or cannot act as trustees any further, my lord. The court should take a cognizance of this matter. And today, if the court leaves the matter, my lord, in the hands of the trustees, there will be no property left, my lord.
My lord, since the Durga Puja is knocking at the doors, they're just simply adjourning so that they can enjoy for their lifetime this thing.
Because, my lord, absolute power corrupts absolutely. Now they have got the power, now they are misusing it. Monday, my lord.
What is your number?
IAGA number 10 of 2024, my
That is
lord.
under the heading
We have
new motion.
served all of
And
them,
my
my lord.
applications are
এটাতে অর্ডার করছি না, এটা এটা অ্যাডজন্ড হবে, কোর্ট
IAG
লিস্ট করবে নিউ মোশনে, নিউ মোশন
Yes, my new motion.
And my matter should appear under the heading G, adjourned motion.
অন মানডে, ওটা থাকবে
But
মানডে।
no further adjournment. It would be recorded in the order. No further adjournment.
Yes.
Grateful.
Affidavit of service filed on behalf of, you are for?
I'm for one of the trustees, Dilip Narayan Dev.
On behalf of the applicant is taken on record.
IAGA number.
Ms. So and so learned advocate for the board of trustees.
Yes, Shoibal Narayan Dev, Devraj Mitra.
Accommodation. Mr. Meghna Dotto, learned advocate for intervener.
No, it's intervener, my lord. Ajanta De, my lord.
Intervener Ajanta De submits that his client has also filed an application. What is your for interim relief? For interim relief.
For
what is 10?
Praise, well, multiple reliefs have been claimed. The first relief is that the first, my lord, a new trustee should be appointed in this
Already
trust.
taken out an application seeking certain interim reliefs. Being GA 10 of
2024.
2024. Is this matters on 22nd? আর ওনার নাম্বারটা নিয়ে তোকে লিস্ট করবে নিউ মোশন।
And my lord, I hope, my lord, everyone has got a copy, my lord, so that they don't come up with a plea on that Monday morning that I have not received a copy. Everyone has, you have received a copy? Yes, they have received a copy.
And it's my humble submission, my lord, before my lord, that no further adjournment should be.
Look at the
Clients, they are
default, my
enjoying
lord,
the trust property, engaging senior advocates, everything is being spent from the trust money. And my client, although being a trustee appointed by this court, is not making the expenses, all expenses from his pocket. The benefits which they are enjoying should be stopped, or otherwise the board should be dissolved on that thing.
On Monday.
My lord, we'll plead Monday.
Item number 30.
Item number 30, Mr.
Right.
Shubham Sengup is appearing for the receiver. His submission to make is engaged in court number 6. Kindly make it pass over for 10-15 minutes. He will come.
My lord, in that case,
My lord, I am an applicant.
Defend number 7B.
Yes, yes.
My lord, I am, my lord, one of the applicants. My lord, I am proposed to, my lord, purchase, my lord, this part of the suit property. My lord, I have made a proposal and I have filed that application. My lord, the case status is that, my lord, valuation was, my lord, sought for. That is, my lord, awaited as of now.
My lord, I appear for defend number 7B in this matter, my lord. I also have an earlier application which is GA11. That application is not appearing today, my lord. So I'd request my lord to kindly keeps it on Monday with both the applications, my lord. Let these two applications.
What is GA11?
GA11 is also, my lord, for sale of the property. His is for purchase, mine is for sale, my lord.
Okay. No, you are purchasing as a co-sharer. You are the
My lord, no, my lord, I am, my lord, I'm a dealer of a property. My lord, I have made an offer to the, my lord, learned receiver, who is, my lord, having the property under her possession. My lord, that has been accepted. And my lord, with regard to, my lord, this particular suit, my lord, there is also, my lord, previously such sales were, my lord, allowed by this honorable court. My lord, I have annexed that order also in my application. So, my lord, my application may be considered. My lord, I have made a proposal for 70 lakhs, which is also negotiable. In my GA 19 of 2024. Lordship
This
will
application, lord, has to be considered with my application GA11, which
see
is
my prayers. My lord, leave, my lord, has been sought in the notice of motion, lordship, at page 5 of my notice of motion. The prayers are there. Well, this is 5 Shivnarayan Das Lane. Formerly, yes, and now it is, my lord, 6 Shivnarayan Das Lane. But I have made a proposal for that 70 lakhs consideration amount.
Lord, I'm appearing for defendant number 11. I am defendant number 11. And defendant number 14 is also here in court. Previously, on the previous day, on 15th of May, we had appeared here. Your Lordship had instructed me to serve notice on the plaintiff's advocate. That we have done, and plaintiff's advocate has received the speed post article on 2nd of July. Then the matter is that, 1 minute, your lord. Pursuant to the order of Honorable Sugato Mazumdar, we had submitted the affidavit in opposition on 15th of May.
Lordship will, let me
Pursuant
assess.
to an order on 17 December 2018.
Lordship will kindly take up, my lord, the last order of this honorable court of 16th May 2024. Perhaps, my lord.
Lord, we have not received any opposition.
11.
This is, my lord, the last order. Lord, these learned receiver, Lordship has got the order, my lord. The communication dated 6th May 2024 made by the Registrar of Assurances along with annexure may be inspected by the learned receiver. The learned receiver is requested to furnish particulars as contained therein to the learned registrar original site for onward transmission of the same to the Registrar of Assurances. So I understand, my lord, this has to be done, perhaps.
My lord, this property had been valued by the court, by the empaneled advocate, empaneled valuer of the court in 2018. And that report had been submitted to the court. ঠিক আরেকটা দেবেন ভাইও বসে
Lord, sorry to.
Wait.
Yes.
So what is in the valuation report?
My lord, so far as, my lord, the proposal is concerned, whether that will be, my lord, suitable. Lordship will kindly take, my lord, the order of 15th April once. Perhaps I should have pointed out, my lord, also along with the 16th May order. Lordship will kindly see, my lord, 15th April 24 for proper adjudication. It starts.
Yes.
My lord, for proper adjudication of GA 19 of 2024 and GA 11 of 2013, it is necessary that actual market value of the property be ascertained. The property is located at 5 Shivnarayan Das Lane, Kolkata, 7,06,000. To ascertain the present market value of the property, a valuation report is hereby called from the Registrar of Assurance, Kolkata. The learned registrar original site shall communicate a copy of this order to the learned registrar of assurance. The valuation report shall be placed before this court by the registrar of assurance on or before the returnable date. My lord, so, my lord, that is why, my lord, that transmission is still underway, as I, my lord, showed to your lordship in the next order of 16th May.
I
So,
beg
my
to
lord, that is
defer.
awaited.
I
So,
beg
my
to
lord,
defer,
I
your Lordship. The property had been valued
Wait.
by the court.
You are Mr. Roy.
Yes, I'm
Please,
defendant number
please hold
11,
on. Please
Ajit
hold on.
Kumar.
You'll get your opportunity. Yes.
my lord, so far as my lord, so my lord, my lord, right now, my lord, the honorable court had sought for the report. It is awaited. My lord, it has to come. My lord, the learned receivers, my lord, counsel has to apprise this court. So, my lord, kindly, I feel, my lord, perhaps, my lord, it should be kept another day. In the meantime, my lord, this process can be.
You have got a copy of the valuation report.
Yes, the valuation report was submitted to the court. It was done by the court, by Justice Soman Sen, and the report was submitted on in 2018.
A fresh report was called for.
As subsequent to that, recently another report was called for by the court, a report from the Registrar of Assurances. But previously the property had already been valued by the court, and that is valued at 63 lakhs.
Perhaps
we were offered by the court. We had offered to buy the property because no other owner was interested. This is an ancestral property, and we need the property for our residence.
Okay.
So the honorable court had accepted our views that we could take up the matter because no other co-owner was interested. Now these other parties who are coming into to the court, they are all outside parties. So actually, we should have a right of preemption to get the property. It is our ancestral property, and we need a property for our residence. We are facing many problems in the existing properties wherever we are.
Okay.
So we need to
May
take
I
up this
insist, my lord?
property.
Lord, this calling for a fresh report of Lord to ascertain the actual market value of the property arose when GA 19 was filed. GA 11 was filed earlier, thereafter GA 19 was filed. When the matter was moved, my lord, I had come up to oppose GA 19. Then, Lord, the Honorable Court having the earlier determination, it has passed the order on 15th of April. But the first line starts for proper adjudication of GA 19 and GA 11. It is necessary. It is necessary that actual market value of the property be ascertained. Hence, my lord, a report was called for.
my lord, we are back to square one. My lord, where we are, my lord. That is, my lord, where we are.
We can find that no report has been furnished yet. Your lordship may kindly keeps it on another day along with GA 11, which is not appearing today in my lord's list.
It is 26 June 2024 register is reported again. आगे report
আমি প্লেন্টিভ
লেভেলের সাথে আছে
বলার নেই তো প্রিএমশনের রাইট আছে নাকি
আচ্ছা
প্রিএমশনের রাইট প্রিএমশন থাকলে তো
আচ্ছা তাহলে ওনার যে অ্যাপ্লিকেশন ওটা আনিয়ে নিন
পাঞ্চাল করে যাচ্ছে
Your for different number
7B, my lord.
7B.
Lord, I appear for the plaintiffs.
The earlier orders.
Lord, I appear for the plaintiffs. Lord, I have nothing to add. Only one thing, Lord, this is fully tenanted building.
my lord, and
আসুন Mr. So-and-so, learned advocate for defendant number 7B. 7B submits that his client has filed an application being GA 11 of 2013 for seeking permission to sell his share. Mr. Shambhuddha Datta, learned advocate for the applicant in GA 19 of 2024, submits that on his prayer, a report was called for from the Registrar Assurance, Kolkata, in order to ascertain the present market value of the property. BD order dated 15th April 2024. Mr. Hoshit, no? Ajit Kumar Roy, defend number 11, submits that you are willing to purchase the property.
Yes, we have been
Sir.
permitted also to purchase the property in 2018. And this information
He
has
is
been given
willing
to
to
the petitioner's advocate
purchase the
and the receiver.
property in question. List GA11 of 2013 along with the present application. Did you file any application for seeking permission?
Yes.
What is your GA number?
No, we have not filed a separate application. We want to file a supplementary affidavit in opposition. We have submitted the affidavit in opposition on 15th of May this year. And
against
we
GA19. GA19, his application you have filed opposition?
Yes.
I have not received any opposition, madam.
We have also not received.
I have not received any opposition.
We have submitted to the current records as directed by this honorable.
That has not been it has been not served upon the parties.
Was there any direction to file any opposition to them?
Lordship, there was a direction in the 15th April order. Kindly takes, my lord. There was a direction, my lord. It is recorded, my lord, at the second page of the report order, at page 2.
Yes.
Fourth paragraph. Defendant number 11, namely Sri Ajit Kumar Roy, is present in court today and craves leave to file affidavit in opposition against GA 19 of 24 and GA 11 of 23. He also submits that he is not willing to sell out the property. Leave is granted to file affidavit in opposition on or before returnable. Now, my lord, it is, to our knowledge, it is not there because it has not been served upon us.
It has been already filed with the current record.
My lord, also
19 in opposition. It opposition. हाँ? ये तो लोग जो एडवोकेट बहुत मुश्किल है कॉन्टेंशन तो तो पार्टी से नाम लेके शुद्ध ऑपोजिशन निकले there is an affidavit in opposition is filed.
My lord, that has not been circulated and has not been served upon me. My lord, I have, my lord, twofold submissions. My lord, one is, my lord, I will my lord, use a reply. My lord, I will use a reply.
Affidavit in opposition to the learned advocates who are representing.
Yes, sir. And further to this, we would like to submit a supplementary affidavit in opposition because our bank has called for certain documents. Only on account of that, we want to submit another affidavit in opposition, a supplementary affidavit in opposition.
First, you serve the copy of this affidavit in opposition to the learned advocate for the applicant.
Yes.
If you intend to file supplementary affidavit in opposition, you can file that. But in that event also, you have to serve a copy. Without serving the copy, not filed because the advocates will not be informed of your opposition.
I see. We will do that. Yes, sir.
Lordship, one other thing. Well, sorry to, my lord, interrupt. My lord, Lordship had recorded the valuation was done, my lord, at my prayer. My lord, really, my lord, it was the wisdom of the court. The court wanted to assert it.
There's another point I wish
to appear on behalf of the receiver. I will repeated submission to the district. Whatever the Lordship would pass the order. I have seen there are previously this matter was came up with such a situation and a similar situation. Justice IP Mukherjee passed a certain direction. Pursuant to such direction, a portion of the property was settled. Now, this is the I say the similarly situated circumstances has been propped up. If your lordship so desire, we will be comply all the direction passed by.
So at that point of time, you are given the duty to execute the sale deed.
Yes, sale deed. Prior to that, the advertisement was made to the newspaper.
Yes.
And pursuant to that, whoever coming up with the higher bid, that has been granted to them. Then after we have executed the this sale deed.
Okay.
Civil properties have been sold.
Yes.
Sir Ajit Kumar Roy, defendant number 11 is directed to serve copy of the affidavit in opposition upon learned advocate for the applicant in GA 19 of 2024. Mr. Roy seeks to file supplementary affidavit in opposition, seeks leave granted to file such opposition by the returnable date.
Yes. And we need another permission. We need a permission to visit the property with the technical people, professional people, because we have to examine the property, what is to be done, any repairs, alterations, etc. Because we had been given permission to buy the property in 2018, in December 2018.
List this matter. अच्छा 11 तो बोलो 11 2030. List this matter after 4 weeks.
My lord, recording of that submission, my lord.
ওইটা on the prayer বলেছিলাম on the prayer ওই market value টাই করেছে ওটা বলে দেন the court directed for assessment of the market
For proper adjudication, lordship had said. I am grateful to your lordship.
11 টা এর সাথে লিস্ট করুন
Grateful.
Grateful.
Item number 31.
My lord, this is the two applications. The application by the defendant number 6, Tata T, my lord, is filing these two applications. That is GA or IA 25 and 26. Now, my lord, IA 26, which is the second application, is for dismissal of the suit and for the plaint being taken off the file. And GA 25, that's the first application, is an application for recalling various orders passed in the year 2023. Now, my lord, this is a suit, as you can see from the cause title, of 1992, still pending. Now, my lord, 32 years have passed since the filing of the suit. My lord, it appears now, this recently we have come to know, my lord, how are we involved in this suit? My lord, the defendant number 4 is Grasim. Defendant number 5 is Hindalco. Then I am, my lord, 6 Tata. And my lord, another defendant is Unit Trust of India. This is Unit Trust was there, my lord. The subject matter of suit is this, my lord, there was a defendant number 1 who is the broker, who is a broker. In those days, my lord, in 1990, lordship may remember, in those days, my lord, you had to park your shares with a broker, and the broker, the transfer deeds used to buying and selling. You maintain an account with a broker, and he, on your behalf, buys and sells shares. So, my lord, the defendant number 1 is the company, and defendant number 2 is dead. Defendant number 2 was substituted in 1997 by wife and son. My lord, Manmal Bhutoria was the original defendant plaintiff number 2. Now, my lord, both these and probably Bhutoria Valve must have been a company owned by this gentleman, plaintiff number 2. So he held many shares, Hasim, Hindalco, and he entrusted all these shares to this broker. My lord, Bajrang Mahabir Prasad. My lord, Bajrang Mahabir Prasad absconded. He's still absconding. You won't find him. He's absconding. And my lord, in 1992, he said, my shares are there. I have, there are many blank transfer deeds lying with this Bajrang. So, and moved an application, got status quo order, my lord, in respect of all
shares or transfer deeds which he may have executed. My lord, nowadays it's no longer possible, this thing, that you park your shares with broker. Nowadays, SEBI regulations have come. It's all online. To protect all this mischief, these broker business have gone. My lord. Number 3 is Calcutta Stock Exchange. That's through where it was traded, my lord, in those days. So whatever it is, my lord, the subject matter of this suit, they got an order probably of status quo way back in 1992. And probably there was a affidavit filed by us that we have nothing to do with this. Whoever it's his share or whose share you get status quo order, there's a status quo order, my lord. Then, my lord, the suit, and we said we are not interested at all, and no one filed. There was a writ of summons served in 1995, probably. This we have come to know now in 2024, writ of summons. So no one filed written statement on behalf of these companies, Tata, my lord, etc. Now, my lord, it so happens that for that, my lord, there has to be a pleading in the plaint that you are illegally, these shares have been transferred to someone or anything. My lord, there was, so far as defendant number 6, I will show you, there was never any pleading. So, my lord, in 1997, after summons was served, there was an amendment done to the plaint. My lord, now from the record, it appears this amended plaint, or when there's a whole-scale amendment bringing on cause of action on a defendant, on a particular defendant, my lord, that summons has to be served. It's a fresh amendment. The records say no fresh summons was ever served to any of these defendants. And after that, my lord, the records show that there have been 10 amendments over the years, one after the other, incorporating various against various persons. No summons served to the defendant number 6 ever. In the meantime, which is not there on record, no one has brought in the record of this case. In 2006, apparently, these shares, my lord, these were blank transfer deeds. On basis of that, my lord, it was floating in the market. It went to a person, he got the shares, he filed apparently a civil suit in the city civil court, making me a party, and this Manmal also a party, and got a decree that I am the owner of these shares. And these shares were transferred in 2026 in the name of these people. This person who got a decree, by virtue of a decree obtained in the site. Everything was there. I told your lordship from 1995, summons not served. The cause of action, original cause of action against me, not pleaded in the plaint. That it is that he is trying to transfer to someone or anything, nothing pleaded. The pleading comes, my lord, as I told your lordship, in 1996 by way of an amendment. After summons, but no summons served to me. So, my lord,
6 pleadings comes against you after the decree is passed by the city civil.
No, decree is passed in 2006. But in 1996, the cause of action in the suit is pleaded by way of amendment against me in 97. My lord, till date, on the basis of the decree that it has been transferred to another person, so cancel that transfer, bring the other transferee party here, not done till date. Not done till date. So, it's not my duty to bring it in, my lord, in this suit. My lord, why I am asking, why I have come now? Because I am not interested. Because the shares, my lord, whoever you want to transfer,
there were another 20, there were about 3,500 shares. Out of that, 2,300 shares apparently were transferred by them to another person. That particular thing was brought on to record in 2015. Again, that particular thing was introduced by amendment in 2015. But again, I am not made a party. No summons served. But amendment introduced. So, my lord, we are remaining with about 1,000 shares of defendant number 6. For this, in 1995 amendment pleading, there is no cause of action. I will show it to you from the plaint. When you amend it in 97, even then you forget to amend, introduce the cause of action, which should have been in there in 1992 as against me. Grasim, there is mention. Hindalco, there is mention. Nothing mentioned about me. So, my lord, why do I come now? Because, my lord, in 2023, I am served, my lord, with contempt notice, and a contempt petition is filed against my client. My client means even Tata Tea has become, my lord, Tata Beverages, Tata, then, my lord, consumer products, which is now 2 times change. No amendment. That's different. But it's change of name. Let me not take these technical pleas. And all the top directors stationed in Mumbai of Tata, my lord, we'll see the names. They are all made parties in the contempt petition. And one director from US, all made parties. And days after days, my lord, hearing is going on. Why? Just look here. In 1992, there was a status quo order in respect of these shares. So you have violated, which was confirmed in 1995. You have violated. Therefore, you are in contempt. Why? So, my lord, whatever it is, this contempt petition was being heard. About 10 days of hearing before Justice presided over Justice Orijit Banerjee. Then another 7 days, not 7 days, 4 days hearing before Justice Basak because change of determination. Because now under the determination, my lord, it is if a judge retires, that jurisdiction, my lord, goes to my lord, that's a division bench. It was my lord, the order had been interim order was apparently passed by division bench because learned judge has been presided over by Justice Ajit Sen Gupta, late Justice Ajit. Then all done in 1990, way back. So he had to go to a division bench. So when my lord, I was briefed because suddenly contempt notices come. My lord, no one is appearing from 1995 in these suits. It is pending and no one is serving summons also. So I get these. So, my lord, no one knows what is happening. My lord, the plaint, I get inspection and we discover, my lord, lawyers discover, look here, there are 10 amendments. So we make a search in the department, right department. Department only informs in March 2024 that no, in March 2024, only one summons was served in 95, which I told your lordship, in 95. Rest, there are 10 amendments which have taken place. And in none of them, summons have been issued in my favor. That's in record. So, my lord, I advise my client to look at the side. I mean, enough, you are flogging a dead horse over there. So we don't want to come in and just intrude in a private matter where shares of Tata, it's small, 2,500 fight between who doesn't, we don't want to get involved. My lord, we are compelled to come and now ask for dismissal. Go to the very root of the matter and finish this suit. My lord, because he said even if you go by the original cause of action, there is no cause of action. The cause of action which you pleaded in 1997 after service of summons, no summons was served. No summons was served. My lord, that's appear from the report. And the actual cause of action which happened in 2006 by reason of the decree, it has gone to a particular transferee that you have not even introduced by way of amendment. Now, I am not going to the 2006 because no one has come out with that case. I will have to go by what is there in the amended plaint. And my endeavor to show to your lordship that in 1997, firstly, 1992 contained no allegation against my lord against my client as far as defendant number 6 is concerned. You tried to introduce a cause of action by way of amendment so as to justify the orders passed in 1992 and confirmed in probably 94 or 95 by the my lord. In the year 1997, assuming for the sake of argument, you introduced this amendment, you did not serve summons. Then, my lord, the amendment is of no effect. So far as my client is concerned, in any event, if you consider the plaint as it stands amended, my lord, because the non-service of summons is a ground for dismissal. My lord, in 1997, you introduced this. So, my lord, in 1997, when you supposedly introduced a particular cause of action, and I say there is no cause of action against my client, even that you did not care to say, serve the summons. My lord, therefore I say that the suit is bad. Now, what is my first application? The first application is recalling several orders in 2023. My lord, these the 12th amendment application was filed in the series. Just have a look at the prayers, my lord. You will find I have asked for recalling of several orders. Has your lordship found that? Yes. They are all of 2023. My lord, this is the time when for the first time, when I come to, when the dead horse is brought to life again, and they start flogging my lord at the in the contempt application, I decide to come and intervene. This has nothing to do with this amendment, anything to do with my client, but I come in because matter is live now. I have come in. And my lord, in spite of I say this suit is there, please take an inspection. I don't know anything about the suit. I come to discover, my lord, all these things and write a letter to the department. So what's the status? I have no idea. And department writes a letter, my lord, in this March 2024, saying, no, summons was served in 95. Nothing has been served to you, but 12 amendments in the meantime carried out. But in the meantime, all these orders have been passed. So I'm asking for recalling of all these orders. Well, this is I've summarized in that, but I'll place the facts, my lord, and order 7. If your lordship, I can proceed and show to your lordship first the dates, as I told your lordship, 1992, 95, my lord, the report of the sheriff that summons has not been served. And then
plaintiff has filed their opposition. You are for the plaintiff.
Plaintiff.
You have filed your opposition?
Yes. Opposition reply. Everything ready in both the matters.
From the last.
Yes. So, my lord, may I, or my lord, whatever your lordship, may I proceed, my lord?
We are left with 1 minute today. So I'm fixing a date where you can place your rest of the arguments. Factual matrix of the case has been placed.
Yes,
that there was no such pleading as allegations against you.
Yes.
Several of the amendments were carried out without serving writ of summons after the amendment. And 2006, there was a decree passed by the citizen.
That has not been even brought into record by
by way of a contempt petition.
I came, in the contempt petition, of course, Manad, I've taken also the limitation you knew about, because limitation, as you know, Manad, in section 20, there is 1 year, etc., etc. I've taken a point that you knew about because shares, you are getting dividends from Tata in respect of other shares.
And what is 26?
Manad, I told you, Lordship, 26 is the dismissal, rejection of the plaint.
Okay.
Because for rejection, Lordship will immediately ask me, oh, now you did not object, these orders are there. Well, I did not know about these orders that summons. So there you are.
Recalling then dismissal.
Yes, yes, yes. Only the last amendment orders I have asked for because it was passed in my presence. So, Milord, your Lordship may inquire why did you not object then? So I have a duty to Milord to answer that.
Okay. Third, Mr. So-and-so, learned hearing on behalf of defendant number 6. Due to paucity of time, the hearing could not be concluded. List this matter on Onion Babu. 1 week for Rapu will take some time. Right. Next Friday?
Next Friday is entirely for your Lordship.
This is next Friday, date to the. Thank you.